For judgment, we may let in jail, certificate of the likely.
So we have allowed the appeal filed by Khairul Islam, but dismissed the appeal filed by Saiful Islam on the ground that the evidence is not the same. The last seen together circumstances available for him, and the chain of circumstances have been established as far as he is concerned. Khairul, we have given him the benefit of doubt. Yes. Yes. Sign all pages. Keep it inside.
Supplementary list for judgment item 12.
Application stands dismissed.
Much.
So it couldn't be more than individual option.
Item 30.
Appeal stands dismissed.
Daily list for motion item 3.
13, 14 together.
13, 14.
Yes, yes.
Obliged.
My lord, in last application, my lord, exponent number 1 and 2 were directed to file affidavit, my lord.
Affidavit has not been filed.
1 and 2 is represented by the union lordship. 1 is by the union.
And extra copy also not sent to us.
You're not filed.
During the course of the day.
Ms. S. Borwa, learned CGC appearing for the response numbers 1 and 2 submits that due to want of instructions and non-availability of and non-service of extra copy of the writ petition. No, due to non-service of extra copies of writ petition and the resultant want of instruction, the affidavit as directed by the order dated 8/5/2024 passed by this court could not be filed. She therefore prays for another 2 weeks' time to file affidavit. Mr. D. K. Bakchil and counsel for the petitioner undertakes to serve extra copies of the writ petition to the Lanet CGC during the course of the day. In view of the above, on the request of Lanet CGC, this matter is directed to be listed again immediately on reopening of summer vacations. Ms. A. Verma, Lanet Standing Council, Home Department, Assam, and Mr. P. Sharma, Lanet GA, Assam, are present on behalf of official respondents.
Deeply.
Instruction लिखी दिया दे आपको फटी जाबो.
Item 24.
Auto copy or paste need.
May please, your lordship.
Yes.
My lord, this petition has been filed against the order dated 16/3/2024, my lord. At page 15 is the order, my lord. It's an ex parte order.
notice was issued, my lord, in a wrong name, my lord. Therefore, the petitioner refused to accept, my lord. But now the declaration is charged by the police to arrest him, my lord.
Lordship, LCR may be called for and he may be protected, Lordship.
But Mr. A.R. Sigdal and counsel for the writ petitioner. This writ petition is preferred against the ex parte order dated 16/4/2024, passed by the learned member, Furnace Tribunal number 3, Borpeta, in connection with FT case number
24 mass.
3235 oblique capital Roman 3, it was oblique 2016, whereby the petitioner has been declared to be a foreigner of the post 1971 scheme. Mr. Sigdar submits that no notice of the reference case was ever served upon his client. Notwithstanding the same, the police is now searching for the petitioner based on the ex parte order dated 16/3/2024. Full stop. Having heard the submissions, no, you're right. Miss A. Verma, learned Standing Counsel, Home Department, Assam, Mr. P. Sharma, learned G. Assam, and Mr. H. Kuli, learned Standing Counsel for the. Sorry.
Lordship,
Election.
notice was served. He refused to accept because his father's name was not correct.
That is not
Lordship has-
correct, my lord.
Lordship has just dictated that notice was never served him.
That is a submission.
Yes,
That is a submission.
Yes,
We are
Lordship.
entitled to record his submission.
I'm sorry, Lordship.
That is not a finding. That's why we are calling for the record. Mr. H. Kuli, is it?
Yes, ma'am.
Whose name should be recorded? Your name? No, that will not. One name.
Yeah.
Huh? AI Ali. Learned Standing Counsel ECI are present. After hearing the submissions made at the bar, we are of the opinion that the LCR ought to be called for before passing any further order in this case. As such, call for the LCR. List this case immediately upon receipt of LCR. As an interim measure, it is provided that the writ petitioner shall not be arrested nor deported till the returnable date.
Lordship, he shall appear before the
However,
SP,
the
Lordship.
petitioner to appear before the Superintendent of Police, Borpeta, and
And Lordship, that surety amount and his iris and biometrics to be captured.
so as to enable his the biometrics of the petitioner and the what is it called, iris? Iris to be captured. The petitioner to also furnish a bond of rupees 5,000.
Item 5.
May I please loss?
Fine.
And in this case, my lord, to go next, my lord, that is
Furnish a bond.
77 lordship. Yes, 77 lordship, the petitioner lordship, reduced herself as.
So it is a contested matter.
Yes, lordship. Her mother was examined, lordship. Her mother was examined, she, my lord, established the linkage with her lordship. Her
At this
mother's,
stage, Lordship, LCR may be called for.
We'll issue notice then.
Yes, Lordship.
my lord, protection.
Heard Mr. H. Ahmed, no? Did you? Heard Mr. H. Ahmed and counsel for the petitioner peruse the order dated 26/7/2023 passed by the learned member FT bracket 5th bracket close Barpeta in connection with FT case number 300/2015 declaring the petitioner as a foreigner of post 1971 stream. Mr. Ahmed submits that this is a contested matter, but the learned tribunal has failed to appreciate the evidence on record in the correct perspective. Full stop. Having heard the learned counsel for the petitioner, we are inclined to examine the matter, stop, issue notice, returnable in 6 weeks. Since Miss who is appearing for whom? Miss S. Borua, learned CGC has accepted notice for respondent number 1. Miss A. Verma, learned SC Home Department, Government of Assam for respondent numbers 2, 3, and 4. Mr. P. Sharma, learned G. Assam for respondent number 5, and Mr. A. Ali, learned SC ECI for respondent number 6. Service of notice upon respondent numbers 1 to 6 is deemed to be complete in this case, extra copies of the writ petition be furnished to the learned standing council, requisite in numbers, so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 7 by registered post with AD. Uh, Call for the LCR. Let this matter be listed after receipt of LCR. Having regard to the facts and circumstances of the case, by way of an interim measure, we hereby direct that the petitioner shall neither be arrested nor deported until the returnable date, subject to furnishing a bond of rupees 5,000 and his appearance before the respondent number 4 within 2 weeks from today for the purpose of capturing his biometrics and iris of eyesight. This will be the operative interim part in the earlier also. That will be hard, this will be his. Yes.
Possible like this.
Item 6.
Eighteen or.
May I please, Your Lordship? My lord, here in this case, the petitioner, after receiving notice,
Contested
appeared in the tribunal. My lord, it is pending, my lord. So appeared in the tribunal and adduced evidence, my lord, she has been cross-examined, everything has been done, my lord. And the case was fixed for examination of the Kapoor secretary, my lord, who issued linkage certificate. Thereafter, the petitioner has taken 3 consecutive steps, my lord, for issuing notice, and notice were issued to the secretary, but secretary did not come to the tribunal. Thereafter, one occasion, petitioner's advocate by mistake did not take a step. And on the next date, he has filed petition before the learned tribunal that I have taken steps, but on last occasion, due to my mistake, the step was not taken. But the learned tribunal has rejected that petition and fixed the case for argument, my lord. Thereafter, the petitioner again filed a petition for vacation of that order, my lord. But the subsequent petition has also been rejected, my lord.
So let the tribunal give the opinion. If you are aggrieved, then this.
Lordship, I have one submission. This matter is of 2018. And if Lordship comes to page 47, Annexure 11, Lordship will look at paragraph 3. From 22 to till 24, they have been seeking adjournment again and again. Lordship, ample time has been given to the proceedee to complete the proceedings, all opportunities granted, and now to stall the process again, before this court, this cannot be accepted at all, Lordship.
No, you make your arguments.
My lord, the learned tribunal has recorded some dates wherein the petitioner and the petitioner's witness also was also examined and cross-examined, my lord. But that date also included in that list.
Where is the order impugned? Where is the-
47, Lordship.
47.
47.
First impugned order, my lord. My lord, I have also annexed on order of this honorable court wherein the petitioner has been granted relief, my lord, in a similar situation, my lord.
Lordship, if Lordship comes to the last paragraph at page 48, the tribunal has observed, learned counsel for the proceedee has submitted that in earlier occasions, proceedee had taken step upon so and so, but the said witness has remained absent to adduce evidence. After that, no steps were taken from the proceedee's part to adduce the evidence of the said witness. Surprisingly, proceedee has filed this petition white so and so without any proper ground. Hence, it is crystal clear that taking such kind of adjournment is nothing but delaying the matter, and as the proceedee is provided sufficient opportunities to adduce further evidences by adjourning the matter as per prayer of the proceedee at the stage of further evidence. Hence, at this stage, this petition for another adjournment is not maintainable in the eye of law. Lordship, let him show what is wrong with this order.
My lord, may I say, my lord, just before that page, my lord, page number 46, my lord, ground is there, my lord.
Hmm.
46 is the petition filed by the advocate, concerned advocate. My lord, apart from this, my lord, in similar situation, my lord,
No, Lordship, all facts in the matters are different. He
No,
cannot.
Let
refer
us
to a
go
model.
one by one.
Yes, Lordship.
You finish it. Whatever you have to say, you
my
finish.
lord, the tribunal has, my lord, noted that there is no ground, my lord. And my lord, the earlier on 3 occasions, my lord, the notice was issued to the, my lord, secretary, Gov secretary. That is from page number 39, my lord. Page number 39, notice was issued, my lord. That is date fixed on 16/6/2023, my lord. Thereafter, my lord, in page number 41, again notice was issued, my lord. And the next date fixed was 6/10/2023. Thereafter, again, my lord, notice was issued, and then next date fixed was 29/12/2023. On that date, my lord,
Hmm.
the advocate
So
for,
oral evidence, what you want to show? You have to produce your documents. You must have already done it.
my lord,
So the tribunal will render its opinion and then you, if you are aggrieved, you
my
assert
lord,
it.
that is
We are not interfering in this matter.
my
Conclude, please. Please conclude.
lordship, that is very much important because, my lord, my lord, the petitioner has no other documentary evidence, my lord. Documentary evidence is not, no other documentary evidence to link his with her father, my lord. Therefore,
This is another process of delaying the matter, Lordship. That's all.
no, my lord,
In,
my
in
lord,
short, Lordship, I can say this.
rather, my lord, by rejecting this petition, my lord, the matter is dragged, my lord.
So all right.
2
Let
3
the
months has
opinion be
already.
rendered and if you are aggrieved, then we will
But-
examine. We'll keep all issues open.
My humble prayer, my lord, kindly come to space number, my lord, 58, my lord. In similar situation, my lord, this honorable court has granted, my lord, TDT, my lord. In similar situation, my lord,
That is why this has happened.
my lord, kindly, my lord, my case may kindly be, my lord.
When the
considered.
court does not grant, then this will
My
stop
lord,
happening.
from 3, my lord, paragraph 3, my lord.
Yes.
In this petition, the petitioner challenged the order dated 4/12/2021 passed by the learned foreigners tribunal for Golpara in case of FT so by which the learned tribunal did not grant adjournment for appearance of the Gaon Panchayat secretary. Who the petitioner wanted to examine to prove certain document. The learned foreigners tribunal held that the petitioner had been granted several opportunities on earlier occasions. That is that. And since the matter has been pending for disposal since 2016, my lord, and the order was passed on 2022, my lord, it would merely delay the proceeding and accordingly declined to grant adjournment. The learned counsel for the petitioner submits that the petitioner has been seeking presence of Gaon Panchayat secretary by taking necessary steps.
How
in
many
that regard.
adjournments you have taken? How many?
My lord, for Gaon Panchayat secretary, my lord,
Yes.
my lord, just.
Of-
My lord, I
Lordship,
have
you
taken
hold
this
from the date from further evidence. If
for from further evidence, my lord, it is, my lord, 26/4/2023, my lord. And the matter was fixed on 16/6/23, my lord. On that date,
from
I have taken
21.
step, my lord. On next date also, 16/3, I have taken step. Sorry, my lord. 19/8, my lord. That was the date. On that date occasion also, I have taken step, my lord. And the matter was fixed on 6/10/2020.
So on 15 occasions, you took time
15
for further
occasions,
evidence.
Lordship.
Lordship.
From-
No, Lordship. That
Alright.
is wrong, my lord. My lord,
Mr. Your name, please?
M.S. Talukdar.
MS Talukdar, learned counsel appearing for the writ petitioner. Also heard Ms. C. Barua, learned S. Barua, learned CG. Mr. Dev
We
Chaudhary,
are together, Lordship.
why CGCs are never present in these matters? What is the last 2-3 days we are seeing union is a party. Nobody appears for the union. What is the matter? Is if the union doesn't want these proceedings to go on, then why don't you shut down the tribunals? Huh? Or should we say that the union is not serious in pursuing these matters? No, but this is not the only case. The previous case also nobody was.
No, concern, because I have been the whole months, I have looked at each day.
No, that's nothing on you. We are asking.
Actually, because the council is not concerned.
Mr. RKD Chaudhary, learned DSGI appearing for the respond number 1. Miss A Verma, learned standing counsel, Home Department, Government of Assam, appearing for the respond numbers 2, 3, 2 and 3. Mr. P Sharma, learned G Assam for respond number 4, and Mr. A Ali, learned SC ECI, appearing for the respond number 5. By filing this writ petition, the petitioner against whom reference case number
Lordship, it's FT in
FT
bracket G.
bracket G dash 4 bracket close dash M public 2026 public 2018 was registered before the Foreigners Tribunal number 4 Gwalpara in Gwalpara district has approached this court, assailing the order dated 2024 passed by the learned FT, rejecting the prayer for adjournment made by the petitioner so as to adduce further evidence. Full stop. Mr. M.H. Talukdar, learned counsel for the petitioner, submits that his client was serious about pursuing the matter, but due to a mistake committed by the learned counsel, no steps would be taken for summoning the witness on 20/2/2024, which has resulted in the impugned order being passed by the learned tribunal. Full stop. By referring to the order dated 7/1/2022 passed by this court in WPC number 61/2022, Mr. Talukdar submits that in similar situation, this court has interfered with the order passed by the learned tribunal, closing the evidence and remanded the matter by granting opportunity to the proceedee to adduce evidence. Full stop. On such ground, a prayer has been made to set aside the impugned order and grant the petitioner one more opportunity to adduce evidence. Full stop. Opposing the prayer made in the writ petition, Ms. Verma, learned standing counsel, Home Department, Government of Assam, has forcefully argued that the petitioner has already availed number of adjournments on the same ground, and taking note of such circumstances, on such ground, with the sole objective of delaying the proceedings. Full stop. Taking note of such circumstances, the learned tribunal has passed the impugned order dated 7/1/2022. Full stop. As such, there is no good ground for this court to interfere in the matter. Full stop. Similar is the submission of learned DSGI as well as the Government Advocate Assam appearing in this case. Full stop. We have considered the submissions made at the bar and have also gone through the materials available on record. Full stop. It appears that the proceedings were registered against the writ petitioner way back in the year 2018, and at the stage of adducing further evidence, as many as 15 adjournments commencing from 21/02/2022 has already been availed by the petitioner. Full stop. It appears that the petitioner wanted to examine the GP secretary as a witness, but despite issuing notice, could not secure his attendance before the court. Full stop. It further appears that recording of evidence in respect of other witnesses have already been concluded. Full stop. It is in those circumstances the learned tribunal had passed the order dated 20/2/2024, by observing that the prayer for adjournment on the ground of adducing further evidence was nothing but a tactics to delay the proceedings. Delay the proceedings, full stop. Having gone through the materials on record and after taking note of the fact that as many as 15 adjournments have already been availed by the petitioner.
6 adjournment,
Huh?
only 6 adjournment, my lord, for reducing
No,
further.
the order says
My lord, order, kindly see that next line, my lord.
15
Since
adjournments, which-
3/3/2023.
which, however,
Yes.
which according to the petitioner's counsel ought to be recorded as 6 adjournments, comma. We are of the view that sufficient opportunity was given to the petitioner to adduce additional evidence as prayed for. Notwithstanding the same, the petitioner has failed to adduce such evidence. Under the circumstances, the learned tribunal was left with no option but to close the evidence and fix the matter for argument, full stop. As such, we do not find any infirmity in the impugned order dated so and so, full stop. Insofar as the reliance placed by the petitioner in the order passed by the division bench in the case of Sobura Khatun, bracket Supra. In the beginning, when you write the writ petition number, give the party's name. After going through the order, we find that the order was passed in the facts and circumstances of that case, and therefore the principles, and therefore it cannot be said that the aforesaid order lays down a principle of universal application, full stop. On the contrary, we are of the opinion that the facts and circumstances of the case are totally different, are substantially different, and therefore does not call for a similar approach, full stop. In view of the discussions made herein above, this writ petition is held to be devoid of any merit and the same is accordingly dismissed. We, however, make it clear that in the event an adverse order is passed by the learned tribunal against the petitioner, it will be open for her to assail the same by taking all legally permissible ground, including the ground urged in the present petition. If prejudice on such count is successfully demonstrated by the petitioner's counsel. The petition stands disposed of. You still have the opportunity to raise this plea. Yes.
May I please?
Yes.
The impugned order is at page 108, your lordship, and your lordship, though it is a contested matter, your lordship.
Hmm.
If your lordship turn to page 103, your lordship
The
will
contested
find.
matter will approach the
Notice
same.
lodge.
We'll call for the record issue notice. You are Mr.
S. Ahmed.
But Mr. S. Ahmed, learned counsel for the petitioner. This writ petition is directed against the order dated. Judgment in order dated 24/4/2024, passed by the Foreigners Tribunal. Foreigners Tribunal number?
No,
You have not mentioned it in your synopsis. How much time you need to file a correct synopsis? We will not pass orders in this kind of synopsis. You have not mentioned which tribunal, what is the case number, nothing.
the case number I have mentioned, your lordship.
In the
It is
synopsis.
FTZ case number
Not
292/10,
in
your lordship.
Where in the synopsis?
Synopsis
Ye-
9.
Hmm?
In the post title, your lordship.
On the prayer of Mr. So-and-so, the matter stands passed over so as to enable him to file a proper synopsis.
Item 8.
Obliged.
May I please, your lordship?
Yes.
This is a contested matter, your lordship, and the opinion start from page number 27, your lordship.
Contested matters will issue notice and
Yes,
call for the
equity
Ms.
protection.
G. Bora learned counsel for the petitioner assailing the judgment in order dated 20/2/2023 passed by the learned member, Foreigners Tribunal number 3, Hojai, Shankardev Nagar, declaring the petitioner to be a foreigner or post 1971 scheme. The instant writ petition has been filed. Ms. Bora submits that this is a contested matter and the petitioner had adduced sufficient evidence to establish his citizenship. However, the learned tribunal failed to appreciate such evidence in proper perspective. Full stop. Having heard the submission of the petitioner's counsel and on going through the materials on record, we are of the view that this matter would call for deeper consideration. Full stop. Issue notice returnable in 6 weeks since Mr. RKD Chaudhary, learned DSGI, has appeared and accepted notice for respondent number 1. Mr. A. Ali, learned SCCI for respondent number 2. Ms. A. Verma, learned SC, Home Department, Government of Assam for respondent number 3 and 7. Who is for number 4? Election, Assam Chief Election Commissioner. And Mr. P. Sharma, learned Government Advocate Assam for respondent number 6. Service of notice upon these respondents are deemed to be complete. Extra copies of the writ petition to be furnished by the petitioner's counsel to the learned standing counsel, requisite in numbers, so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD. Heard on the prayer of interim relief, same order. Call for the records, right? List after receipt of LCR. And the interim relief, same thing. It will be SP,
Hojai Lordship.
SP Hojai.
Item 9.
May I please, Lordship? Well, petitioner before your Lordship declared to be a foreigner well, after 1970.
Contested matter. Contested matter.
Lordship.
So then we'll adopt the same approach.
Yes, Lordship.
Lordship, here we are submitting that well, in a fresh proceeding, he is declared to a foreigner. However, in an earlier proceeding, he was declared to an Indian man.
So what is the order you are seeking today? Allowing the writ petition.
No,
Then what you are seeking? What order?
Lordship, impugn order.
Lordship,
Foreign.
call for the records of both the cases. He has 2 references against him. Earlier Indian, now foreigner. So let the records of both the cases
No,
come this court.
why
will judge.
that he will produce? If he is declared an Indian national, he will produce the records.
No, he will produce, but this.
But
court
was it
will also-
produced before the tribunal now?
Had
Was the
he-
tribunal
had
aware
he-
that you were
yes,
earlier-
Exactly, that he has to apprise the
Well,
court.
that opinion was exhibited before the
Exhibit number?
exhibit number 5, my lord. Page 43 is the opinion.
No. Show us from the order of the tribunal that
Yes,
this,
my lord.
this was there.
Yes, my lord. Page 119. 119, my lord.
See, Mister, your name, please.
K. Roman, my lord.
K. Roman. We would have granted you an interim protection,
Lordship.
but now we will not.
Well.
You earn your order, you argue. Because you have disturbed the court while.
Sorry, well.
dictating it. You argue how
I'm
you
sorry, my lord.
make out a case on facts.
Sorry, my lord.
Yes, to us, why we should interfere in this.
Oh, I'm sorry, my lord. Extremely sorry.
Sorry is not the argument. You have to come up with an argument. Don't think the court proceedings are for joke.
No, it's just
No. You argue now.
my lord, I'm trying to draw attention of the.
We don't want your attention.
Sorry, my lord.
You
Yes.
argue now. What is your case presented? We'll see. If there is ground, then we'll do it. We were adopting a similar standard in other cases.
Man,
You said no. So now you make out a case.
I'm sorry, my lord.
Or when do you want it?
Man,
Will not pass an order today unless you make out a case. This court can be ruthless sometimes. Don't interfere when the court is passing an order. Yes,
Sorry.
argue. Argue, please.
my lord, page 43 is the my
Yes.
lord, earlier opinion.
Page 43.
Yes,
Show us where you have shown the opinion to the tribunal now. Where is it reflected from the order?
yes. Page my lord, 119 is the my lord.
Page 119.
Yes, my lord.
Hmm. Which part?
Part my lord, number 1, 2. 10 number line, my lord. From
Sorry,
right,
119.
yes, my lord, page 19, line number my lord, 10, my lord. There is mentioned that exhibit 5
Hmm.
is certified copy of order dated 19/7/99 passed by IMDT Torong Mongoldoy declaring OP to be the not foreigner within the meaning of IMDT Act 1983 in FT case number so and so on.
Where is exhibit 5? Where is that order?
That is my lord, 43 page.
Yes. Yes.
Married.
Mm-hmm.
OP Shukur Ali, son of Joinal Abidin, is present. He has been suspected as an illegal migrant. Seen the written statement and documents submitted by the OP. Present age of the OP is about 19 years. The OP was born at village Undulazhar under Shyamabari Mauja. He is Dhula of Dorong district. Seen the certificate issued by the Sarkari Gambura of village Undulazhar. Seen this school certificate. As per the voters list of 1985, office father Joinal Abidin was listed as a voter in serial number 166, house number 55, under 67 Mongoldoy LSC. Name of Kazimuddin alias Kazi Fakir, father of Joinal, office father, was listed as a voter in serial number 431, house number 106.
All right. So earlier it was a proceeding under the IMDT Act,
Lordship,
and this is under the Foreigners Act.
my lord.
So show us why a declaration under the IMDT Act would be binding on the Foreigners
My
Tribunal.
lord, the subsequent my lord, proceeding also my lord, under IMDT. That was my lord, that may be my lord, reflected from notice. My lord. Notice my lord, page 32 my lord.
So why should we hold that the earlier opinion is binding on the Foreigners Tribunal in the
Well,
present case? Where is the law? What is the law about
My
it?
lord, we are, that's why we are trying to draw attention of the court.
Sorry?
As per principle of res judicata, my lord, fresh proceeding may not be my lord
So
permissible.
show us the judgment.
Yes, my lord. My lord, two paragraph we quoted in our petition, that my lord, paragraph 13, my lord, of our petition.
Which is the judgment, Mr.
Lord. My lord, today we, extra copy could not, my lord, bring today.
No.
My lord, it is reported in 22/3 GLT 94, my lord. May I read out, my lord?
Yes. Today you didn't bring it. When will you bring it?
My lord, after some time, my lord.
After some time.
Yes.
All right. First, call it as up as last item
Lord.
of the day.
Of
Last item of the day.
Lord.
Ms. Verma, you are not planning to go home early?
My other colleagues would be there, Lordship.
Meet your lordship.
Yes.
Your lordship, this matter is ready regarding service and also it means the affidavit has also been filed. So it can be fixed for hearing.
Fixed
is-
for admission.
Yes.
Mr.
In fact, Lordship, on the last occasion, I had raised a preliminary objection regarding the maintainability of the petition. If your Lordship will come to the cause title for a moment.
So we'll put it up for admission then after occasion. Mr. S. Dattal, counsel has appeared for the petitioner, Mr. R.K.D. Chaudhary.
I have a 1 and 2.
Correspondent numbers 1 and 2.
4, 5, and 6.
Mr. Dinath Leonard, additional senior government advocate Assam has appeared for the respondent numbers 3 to
4, 5, and 6.
4, 5, and 6. Not 3.
3 is the NHS.
Three,
NHS, National Human Rights Commission.
Okay. 4, 5, and 6. It is submitted to the bar that this matter is ready as regards service and can be taken up for admission. Since the question of maintainability of the writ petition is still open, registry to list the matter for admission after the summer vacation.
Item 11.
Yes, what is this IA?
IA Millard for actually it is correction. Earlier will I approve this own code Millard code, honorable court directed me to approve for the Suvarnabhumi police Bozali for bail. I approved their Millard, but the Suvarnabhumi police office said Millard, you should approve the SP Bogota because earlier the case was started from Bogota. I reside in Bogota district, but subsequently creation of a new district for Bozali, it was transferred to Bozali. Now, honorable courts order Millard. Your lordship, by this honorable court Millard, page 10, paragraph 7.
So instead of Bajali, it should be Barpeta.
My lord.
There is some confusion these days because of district's lordship. We do not have any objection to this.
All right. Heard Mr. A. Rushi, learned counsel for the applicant, also heard Ms. A. Verma, learned standing counsel, Home Department, Government of Assam, Mr. R.K.D. Chaudhary, learned DSDO, and Mr. P. Sharma, learned G. Assam, appearing for the official respondent. This IA has been filed with a prayer to modify, public, clarify the order dated 6/5/2000 passed by this court in WPC number 614/2024, whereby the applicant stroke writ petitioner was directed to appear before the superintendent of police bracket border bracket close Bajali so as to avail the benefit of interim order passed by the board. Mr. Rashid submits that due to the reorganization of districts in the state of Assam, there is some confusion as to the as to which of the superintendent of police would have jurisdiction in such matters. First, when the applicant approves the SP border Bajali for compliance of the order dated 6/5/2024, he was asked to approach the superintendent of police bracket border, bracket close Borpeta, as a result of which the applicant has been prevented from availing the benefit of the interim relief granted by this court. As such, this IA has been filed seeking necessary clarification. The learned departmental counsel appearing for the official respondents have fairly submitted that this is a genuine case where a clarification can be granted since the applicant cannot be held to be liable for confusion, if any, in the matter. After hearing the submissions advanced at the bar and on going through the materials available in our group, we dispose of this IA by clarifying that the applicant, in order to avail the benefit of order dated 6/5/2024, shall present herself before the superintendent of police bracket border bracket close Borpeta in terms of the order dated 6/5/2000 Borpeta instead of superintendent of police bracket border Bajali in terms of the order dated 6/5/2024 within a period of 10 days from today. With the above observation, the IA stands disposal.
Welcome.
What is this? Main case. Main case, list after vacation, main case.
Series letter.
Yes,
My lord, yesterday your lordship desired that
Yes.
I should address on the question of repugnancy, my lord, and which my lord, Mr. Bora was arguing. I'll try at that. But before that, my lord, this item 98,
yes,
I think, so long I have, my lord, question the constitutional validity and virus, ultra-virus or intra-virus of section 3(1), Roman 1,
Mhm.
then 3(1), Roman 7, then 3(9), Roman 7, section 3(2), and section 4(2), Roman 3. Now, my lord, I have two other clauses and sections.
Hmm.
I'll try to cut short, my lord, my remaining grounds and arguments here in this case, my lord, and I have also cut short the list of decisions to be placed before your lordship. We have no point showing that this is the case, this was followed here, then again here, then again here. I have cut it short. To say it. No point. The ratio remains, as long as the ratio remains. And unless the government comes up with an overruling decision of the Supreme Court judgment, my lord, I cut short my, not necessary to show 8, 9 decision. Now, my lord, my next point, which I am arguing, is on, my lord, my challenge to the validity of section 8(6), which your lordship will find at page 218. Take on this.
One hundred and 18 of your writ petition.
Yes, Lord. This is, my lord, under the head terms and conditions of service. Here, I am reading 8(1) first, then skip the other subsection. Subsection 2, provisions of this act and the rules made hereunder, all rules including service rules and the rules of conduct and discipline, which are applicable to the state government servant. State government servant.
Yes.
Because a provincialized teacher, once provincialized, becomes a state government servant. Of the corresponding ranks shall be applicable to all teachers of educational institution whose services have been or to be provincialized under the provisions of the Trade Act. Then your lordship may come to 6 at page 220.
Yes.
Here it says, the teachers and tutors provincialized under this act shall hold personnel posts to be created for provincialized, the word personnel, of their services. This post shall be outside the cadre, which shall stand abolished on cessation of service by the concerned teacher or tutor, as the case may be, due to retirement, death, resignation, or any other reason whatsoever. So what this subsection 6 of section 8 has done, that any teacher whose service is provincialized in respect of a post, not in respect of person, a post of teacher or lecturer in any given subject, and on his retirement, the next incumbent with equal or at times even better qualifications ought to have filled in that post. The question is not persona, question is persona designator. It is the chair of the teacher, chair of the principal. That is post and that is provincial. And there cannot be, my lord, provincialized succession as ex-cadre teachers. So it is the chair, my lord, that is important. It is the chair, principal, vice principal, chair, but teacher, head of the department, that is important. So I'll try to say we, my lord, we bow to the chair, persona designator, before your lordships. It is not the person, my lord, it is chair we bow down to. Next man comes. You cannot do it here. And even, my lord, 2011 Provincialized Act is gone. We are discussing 2017. Nowhere, my lord, even by an implied repeal, I don't know, subject to correction, the provincialization of the Assam College Employees Provincialization Act 2005, it is still in existence. And my lord, I take your lordship to three particular section and subsection of the 2005. It is on page, নতুন book on 490.
Yes, it is.
My lord, I'll, lordship may take page 490 of this book. New one. The 2005 Act is there.
Page 490.
Yes. Because even otherwise, after my lord declaring the 11 Act as void, until the time the 17 Act was enacted, there is a period, length of period. So things were moving and existing then definitely under this Act. Things were not moving or could not have moved in the air. Therefore, my lord, let them say what they have to say about the 2005 Act.
So what is your argument?
My argument is, my lord, kindly see the preamble here of this 2005 Act. Whereas it is expedient to provincialize the services of employees of non-government colleges in receipt of deficit grants at that time deficit grants from government. Then section 3 said, 491,
Yes.
subject to provisions of Article 30 and 309 of the Constitution of India, all employees of the colleges, save as except employees who exercise option to continue in the existing terms and colleges, shall be deemed to have become the employees of the government on and from the date on which the colleges have been brought under the system. And then see next page. This very section 3. Clause C says, the posts in each provincialized college shall constitute an independent cadre for each category of employees except the post of principal. So, my submission before your lordship is that government, if you provincialize, you provincialize. If you don't provincialize, you don't provincialize. Somebody is not fit to be provincialized. Once you provincialize, you cannot say that you are provincialized during your lifetime. If you die before your retirement or on your retirement, nothing. Nobody comes in and fills up the post. These students are there in batches. The subjects are there in batches. So this creation of treating ex-cadre, in my submission, is not tenable. And then section 60. There was also, I believe, section 6 was also there. Section 6 says appointments of Then Lordship may take note of section 6 of this 2005 Act. Selection and appointment of employees.
Yes.
Appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective colleges in accordance with the rules and procedures of the government in force. So one can be provincialized only after going through the formalities of the rules and procedure for such provincialization and having the requisite qualifications as mandated by the Malaya Central Acts and the University Acts. So once you provincialize, in the garb of provincialization, you cannot create a personnel post. You cannot make it personnel. Post is a continuous post. And MA
Yes.
MA with 52.5% or 50% with net or slate was provincialized during the, suppose in the third year student, second year, halfway through, he retires.
Yes.
Then the next subject teacher, who is equally or better qualified, might have joined later on in service, he should fit in. That's my case. And that's where this provision is, my lord, this provision is void. Retirement, date or resignation for any reason. Then my lord, the question, I have also, in the cost title of this petition, I questioned the, my lord, incompatibility between section 2T and 2U, the definitional sections. Lordship will find that, my lord. Let us see first the definitional clause at page, no, 2. Your Lordship will find it 208. Here, the definition of teacher is given by 2T and tutor is given by U. Now, let us read, my lord. T. Teacher means teachers, assistant teachers, classical teachers, and also includes lecturers, assistant professors, associate professors, professors, principal, vice principal, demonstrator, headmaster, assistant headmaster, superintendent, so-and-so, and any person of the teaching faculty working in the venture educational institution. We are here. Having required educational and professional qualifications as per norms and standards fixed by the Right to Children, National Council Act, University Grants Commission, and the relevant rules framed thereunder, or any other act, as the case may be. This any other act may be central or state, as applicable on the day of provincialization and whose services are provincialized in this act, in the post of teacher or any other post in the teaching faculty, but not as a tutor under this act. Then come to you, my lord. Let us see how tutor is defined. Tutor means and includes teachers. Teacher does not include tutor, but tutor includes teachers. And teacher was defined in T. I mean, at times, my lord, I feel that it is a badly drafted legislation with so much contradictions. Tutor means and includes teachers, assistant teachers, classical teachers, and also includes lecturers, assistant professors, associate professors, professors, principal, vice principal. A tutor can be a principal. Demonstrator, headmaster, assistant headmaster, superintendent, assistant superintendent in a provincialized educational institution under this act who are eligible for provincialization of their services, whose services cannot be provincialized in the post of teacher under the act due to lack of his educational qualification. So therefore you make him, are you competent to legislate it? The question will come to that extent. Required as per right to children, due to lack of his education, required under right to children, National Council, University Grant Commission, relevant rules, regulation, fair under, or any other act, as the case may be, as applicable in the date of, on the date of provincialization. However, his service is provincialized as tutor with separate terms and conditions to be notified by competent administrative department. Then the proviso, provided that tutor shall not be eligible to hold the post of professor's principal. Here the proviso makes it, I'll show it, its contradiction with the schedule. Professors, principal, vice principal, headmaster, assistant headmaster, superintendent, as the case may be in an educational institution, provincialized by under this act. Then university is defined, my lord, giving affiliating university. In our case, my lord, it will be Dibrugarh and Guwahati University. So, my lord, now it is incompatible to the schedule, which is your lordship will find at page 228. Since
Yes.
now, my lord, the schedule is under 8.3. Let us see 8.3, what 8.3 says. 8.3, your lordship will find. 228, terms and conditions of service. It starts from 8.1 at page 218. Subject to the provisions of this act and rules made thereunder, all rules, including service rules, and the rules of conduct and discipline, which are applicable to state government servant. This I read already. Servant of corresponding rank shall be applicable to all teachers of educational institutions whose service have been or to be provincialized. Now come to 3. For the tutors whose services are provincialized as tutors under this act, there is
You are reading from which part?
this very my lord, section 8, my lord, 219.3, subsection 3.
Okay.
8.3, this section 3, for the tutors, page 219.
Yes.
3. For the tutors whose services are provincialized as tutors under this act, their scope of work and other condition of service shall be notified by the concerned authority department separately. Now, this is important. The emoluments for tutors shall be paid at the rate as specified in the schedule appended to this act, subject to the condition that enhanced emoluments after 2 years as per schedule shall be admissible in respect of a tutor on submission of satisfactory performance report by the head of the, it is like a teacher in waiting in as an appendix, my lord, tutor, basically. Apprenticeship. Can that be a concept? The emoluments for tutors shall be paid at the rate as specified in the schedule appended to this act, subject to the condition that enhanced emoluments after 2 years as per schedule shall be admissible in respect of tutor on submission of a satisfactory performance, like a probationer in government servant, probationer government servant. Report by the head of the concerned educational institutions to the drawing and disbursing officer after completion of 2 years of service from the date of provincialization. In the event of subsequent acquirement of educational and professional qualification by such tutors within 5 years from the date of provincialization, they shall be eligible for upgrading their post Now, in between a probationer post is created, then they will be upgrading their post as teachers. In the event of failure in acquiring required, so he shall continue as a tutor. Net slate is otherwise a requisite educational degree or qualification prescribed by the University Grant Commission and the regulations framed thereunder. So even if he fails to acquire those, either he has to be provincialized or he is out. He will be accommodated as tutor. The scope of work and other terms, 4 says, scope of work and other terms and conditions of service of tutor shall be notified by the respective administrative department separately. Now, here already your lordship has seen, sorry, that the act referred to the about tutors, emoluments and all. These are the provisions guide that 8.3 and under rule 8.3 the schedule is, my lord, framed, which your lordship will find at page 220, 228. Come to 228 page.
Yes.
It is this schedule is under section 8.3, which I have just now read up. Section 8.3. Now it is fixed salary admissible to tutor. Here it says category of post held by the employee in the institution prior to provincialization. Degree college principal. Fixed salary first to second year. Fixed salary 36,000, 40,000. Assistant professor 27. So principal lecturer, junior college. So you are saying that even as principal assistant professor, a tutor is given fixed salary. And in fact, one of the later cases group, my lord, where I am engaged, the post was called principal tutor. Principal tutor. I will come with that in the relevant group, my lord, not today. So, my lord, what I say, all these provisions, there is completely, my lord, contradictory to each other and contradictory to the overall scheme and tutor. I am not immediately going to the extent of competence of the legislature to create a post of intermediary post of tutor. That may be a question to be seen. In any case, now what I'll be trying to hammer before lordship, that so long I have challenged 3.1 Roman 4. I have said that there cannot be a post called additional post. Then section 8.6 and then and various other petitions. These are the same clauses. Then yesterday I drew your attention about the virus of section 2J, section 3.1.1.4, section Roman 9. 15 students in the last examination appearing, that is Roman 4, Roman 7. 150 students, that is Roman 9. I have already challenged, I will not repeat. I will give a gist of the arguments in writing, my lord. Then section 3.2, then section 4.2.3. And today, my lord, I pointed about the veracity or otherwise of section 8.6, whereby you provincialize a person during a tenure, a post. You cannot provincialize. What you provincialize is the post, not the persona. If you at all you provincialize or you don't provincialize, once you provincialize, you will have to provincialize the post, not person. At 58 years, you provincialize a teacher. 60 years he retires, only for 2 years. You are provincializing your post. The students are same, classes are same, board teachers are same. I am the next man. And as your lordship know, once he becomes a government servant, there is also a seniority, prospect of seniority and promotion also. Every college, there is a gradation list. So suppose your lordship ultimately, all these 8 or 10 sections, subsections, clauses, the validity have been changed, which your lordship will answer in the judgment. Now, in the event, suppose out of these 10 clauses, subsections, clauses, ultimately your lordship hold that 4 of these provisions are bad. The remaining 3 are good. Then my question will be, your lordship will have to see where in that event, the doctrine of severability, the corollary of which is doctrine of inseverability comes in. Forget about the act as a whole being repugnant, like 2011. Suppose certain sections are repugnant, even that the repugnancy will come. I'll come to the repugnancy argument as your lordship desired. Now, innumerous subsections, sections, and clauses of the Impugned Act are intrinsic, interspersed, and unseverable. If some or all the impugned provisions in this series are found to be invalid by your lordships, then the remaining provisions, even valid, are so mixed up and inseparable from one another, these invalid sections must result in invalidity of the entire act. As per the doctrine.
Otherwise, it will throw the statute off balance.
And that can be said, and Supreme Court has said in a way, that if after the invalid portion is expunged from the statute by the government, assuming your lordship, my lord, hoping that your lordship will find something wrong with some of the provisions, if after the invalid provisions are expunged from the statute, what remains cannot be enforced without making substantial alteration, modification, then the whole of it must be struck. That is the principle, and this is a good old principle. The concept being from the American jurisprudence, 1957 Supreme Court 628, it is a 5 judges concurrent judgment. It is still holding the field. I will place this 1957 judgment. Copy it there. I will read my book, my lord. I have separate copies for your lordships. AR 57, 628. I took no flag more as no. Yes. Here I will take your lordship to paragraph 21. And then paragraph 22. Lordship, I will look Asana, Kumano. You can see 15 of this printed judgment, my lord. Page 15 of this printed judgment. Below the page is there. Monopat. Online. Online. Have you also got?
You're referring to paragraph 21. Yes.
Paragraph 21 would be 15. Below. What is lordship?
Yes, please.
My lord, may I read? In 1950 SCR, this is 5 judges, lord. Kindly have a look at, my lord, the judgment where starts 57 Supreme Court, SR Das CJ, Venkateswara Iyer Singha, SK Das. 5 years. Then 21 says, in 1950, AR 51, the question related to the constitutionality of 4(2) of the Central Province and Bearer Regulation Manufacturers of Bidij, Agricultural Purposes Act, so and so, which provided that no person residing in a village specified in such other shall, during the agricultural season, engage himself in the manufacture of bidij, and no manufacturer shall during the said season employ any person for the manufacture of bidij. This code held that the restrictions imposed by 4(2) were in excess of what was requisite for achieving the purpose of the act, which was to provide measures for the supply of adequate labor for agricultural purpose in bidi manufacturing areas. That purpose could have been achieved by limiting the restrictions to agricultural labor and to defined hours, and that as it stood, the impugned provision could not be upheld as a reasonable restriction within 19(1)(g), dealing next with the question of severability. It's quoted, my lord. The law, even to the extent that it could be said to authorize the imposition of restrictions in regard to agricultural labor, cannot be held valid because the language employed is wide enough to cover restrictions both within and without the limits of constitutionally permissible legislative action affecting the right. Now it should be noted that the impugned provision section 4(2) is by its very nature inseverable, and it could not be enforced without rewriting it. The observation aforesaid must be read in the context of the particular provision which was under consideration. This really is nothing more than a decision of the severability of the particular provision which was impugned therein, and it is open to the same comment as the decision of 1950. That was also one of the decisions distinguished in 1951. The resulting provision may thus be stated: when a statute is in part void, it will be enforced as regards the rest if that is severable from what is invalid. It is immaterial for the purpose of this rule whether the invalidity of the statute arises by reason of its subject matter being outside the competence of the legislature or by reason of its provision contravening constitutional provisions. Either way. Either way. It doesn't matter if the subject matter enacted being outside the competence of the legislature or legislative competence, or it is contravening some constitutional provisions, mostly Article 14 and 16 in all the series cases. Then 22, my lord. That being the position in law, it is now necessary to consider whether the impugned provisions are severable in their application to the competitions of a gambling character, assuming, of course, that the definition of price competition is section 2D is wide enough to include also competitions involving skill to substantial degree. It will be useful for the determination of this question to refer to certain rules of construction laid down by the American courts, where the question of severability has been the subject of consideration in numerous authorities. They may be summarized as follows. Now, one, these are the underlying principles of severability doctrine. In determining whether the valid parts of a statute are separable from the invalid parts thereof, it is the intention of the legislator that is the determining factor. The test to be applied is whether the legislature would have enacted the valid part if it had known that the rest of the statute was invalid. Reference given. If the valid and invalid provisions are so inextricably mixed up that they cannot be separated from one another, then the invalidity of a portion must result in invalidity of the act in its entirety. On the other hand, if they are so distinct and separate that after striking out what is invalid, what remains is in itself a complete code of independent of the rest, then it will be upheld. If the remaining parts, it is self is competent, complete code. If it is a complete code even then it will be upheld, notwithstanding that the rest has become unenforceable. Even when the provisions which are valid are distinct and separate from those which are invalid, if they all form part of a single scheme, which is intended to be operative as a whole, then also the invalidity of a part will result in the failure of the whole. They are doing it as per a scheme, streamlining, financial constraints. They have a scheme. Nice to have. Scheme means that is a policy. And Supreme Court cases and also the 2011 judgment, while reading, I have shown, my lord, that the policy, even the policy will have to be rational basis. Have to have. You cannot adopt a policy which is anti-people, which is anti-teachers, anti-students. That will also not escape judicial scrutiny. Continuing, my lord. 4. Likewise, when the valid and invalid parts of a statute are independent and do not form part of a scheme, but what is left after omitting the invalid provision is so thin and truncated as to be in substance different from what it was when it emerged out of the legislature, then also it will be rejected in its entirety. The separability of the valid and invalid provisions of a statute does not depend on whether the law is enacted in the same section or different section. It is not the form, but the substance of the matter that is material, and that has to be ascertained on an examination of the act as a whole and of the setting of the relevant provision therein. This is a, my lord, decision and the principles. Every sentence is important. If after the invalid provision is expunged from the statute, what remains cannot be enforced without making alterations and modifications therein, then the whole of it must be struck down as void, as otherwise it will amount to judicial legislation. Pausing here for a moment, my lord, in the instant cases, one thing is noticeable.
Yes.
Pausing here. 2011 Act was declared to be void by the division bench on concession. They were given time for 6 months or 8 months to come up with a well thought over legislation. They didn't do that. They were very prompt enough in bringing without much thought process in the legislative exercise and brought in 2017. Then they realized that no, this is the act. We must impound something, incorporate something which takes our so-called policy ahead. Then the 2018 amendment. It is not one section or two sections ahead. It is a huge amendment. It overhauled the 2017 Act. It changed the characteristics of the 2017 Act. That is the thought process. And while doing that, so many legislative mistakes, we cannot call it legislative mistakes. We will call that incompatible intra-virus and ultra-virus provisions and unconstitutional provisions were unrealistically incorporated in the 2017 Act by the amendment. This happened to you. Now, continuing again, my lord. 6 I was reading. If after the invalid portion of the portion is expunged from the statute, what remains cannot be enforced without making alterations and modifications therein, then the whole of it must be struck down as void, as otherwise it will amount to judicial legislation. Otherwise it will remain, the term is judicial legislation. Otherwise it will amount to judicial legislation, not state legislation. 7 says, in determining the legislative intent of the question of separability, it will be legitimate to take into account the history of the legislation, the object, the title, and the preamble to it, history, not only provincialization is a concept which not only started in 2011, it started right from 2007 to 1978, 1977. Then 2003 rules, 2005 rules, rules after rules. So it is a concept developing. Initially, for the first time after independence, it was thought, whoever may be in the government, 77, that no, these school venture school teachers required to be provincialized because we have not been able to establish schools, even ME schools and high schools in the interior localities of the states. So that is the job of a welfare state. Then here it said, in the result, both the contentions must be found against the, and these petitions must be, government came. So these are basically the jurisprudence of American jurisprudence. Now, my lord, the question is, at the dawn, after the constitution, initial years, my lord, actually the British laws and the American laws obviously was taken as a source jurisprudential values by the apex court and various high courts, my lord. But later on, after during the last 75 years, my lord, our own jurisprudence has evolved. There are many other cases, may not be on this subject. So there are lesser and lesser references to the American jurisprudence. They remain. Constitutions are different. Britishers, they do not have a written constitution. They have the court system, but these are still being followed. But 75 years, my lord. So this is a very old judgment. 5 judges, this still holds the free. And your lordship I'll call upon your lordship to address on the question of 7. Finding the nitty-gritties of every call. Maybe lordship may find 3 of the clauses all right. But if at the same time, your lordship on merit, on constitutionality, on the question of ultra-virus or intra-virusness, whole, that well, this section, subsection this section, clause this section, clause this section, clause this are invalid, then this question of severability definitely. So that is about my case, my lord. I am just, of course, after I'll have the last reply, then I will give a very comprehensive note so far as this item is concerned. And then, my lord, about the desire your lordship expressed yesterday that
Yes.
I should also
Yes,
address the question of repugnancy.
yes.
So actually, day one, I hinted.
Yes.
That basically all these teachers and the other levels, higher secondary, junior secondary schools, they are long-serving teachers, and 3 things are clear that if not all, most of them have the requisite educational qualification, even otherwise to be provincialized. It is heartening to see that for even after serving for 25 years, 20 years, they have not yet been provincialized. Here they have not been provincialized because their provisions are standing as a stumbling block. All the colleges that they have been serving have long ago been affiliated either by the Dibrugarh University or by the Guwahati University or by Silchar University there. Then the colleges and the venture institutions which have been of various levels, which have been established, were definitely established after receiving the concurrence from the government at the threshold. Otherwise, one cannot run an institution. One has to start it from the first year, then it goes to 2nd, 3rd, and 4th year. Now it is 4-year degree course. Therefore, what is to be seen is whether 1 or 2 of the provisions, as I have just now said, are contrary to or overlapping with the any central act, the subject matter of education under the entries of the two lists, and whether the will be repugnant. It has, if it is repugnant, it has to be repugnant under Article 254, 1 and 2. And in case it is contrary to, that is the second link. State act, you are disregarding the central act, is gone, it is repugnant. If the second link will be, if there is another state act which is providing for some things, and you in this act are providing something else, then, my lord, it will be contradictory to the same very state act. And as I said, my lord, in the absence of non-static clause, or no overriding provisions, the presidential assent was necessary. And in this case, as I have shown, gazette notification, it received on the gubernatorial assent, which is not enough. Then, on repugnancy, my lord, I'll refer to Bora's argument, my lord. Bora yesterday. On this. Manual. Section 12A of the NCT Act 93.
Yes, you're referring to which act?
12A, page 657 of this. Act is, my lord, National Council for Teachers Education Act 1993. If it is the volume, then it should be at page 657. Manual. No. Oh, Lordship, it's not in the education manual. If you get, it is a central act, my lord. I am reading from AI manual. By not getting a bare act of this?
Is it available?
I think yesterday it was shown.
Yesterday, 2009 Act, RTE Act and rules were. referred
Yes,
to.
yes.
You are also referring to those.
I am referring to, my lord, RT Act is different. That is right to education, my lord, up to class 7, children up to.
Mr.
my lord, the-
Bora was referring to repugnancy in the context of the RTE.
That's what. That is not my brief, primary education. But some of the colleagues are having the brief challenging, my lord, not getting provincialized at the primary level and the act. If the act is repugnant, say to the Right to Education Act and the, my lord, the Children Act, Central Act, it will be repugnant. If it is repugnant to the University Act, it will be repugnant. College level, it will be repugnant. So repugnancy, maybe if in any layer this 2017 Act is found to be repugnant, it is gone.
One minute. Yes, try to get that act. National, yes. Yes, you can proceed.
I'm reading. Malak 12A.
Section.
12A of the 93 Act. It was actually inserted in 2011. It was inserted in 2011 by Central Act 18 of 2011. And it came to effect, this 12A came to effect from 1/6/2012. power of the council to determine minimum standards of education of school teachers. For the purpose of maintaining standards of education in schools, the council may regulate by regulations determine the qualifications of persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary, senior secondary, intermediate school or college. Already title of the section says minimum standards of education of school teachers, but in the language of the section it says for the purpose of schools or all levels or college by whatever name called, established, run, aided or recognized by the central government or a state government or a local or other authority. Next page, proviso. Provided that nothing in this section shall adversely affect the continuation of any person recruited in any pre-primary, primary, upper primary, secondary, senior secondary or intermediate schools or colleges under any rule, regulation or order made by the central government, a state government, local authority or other authority, amended before the commencement of NEC Act 2011, solely on the ground of non-fulfillment of such qualification as may be specified. Provided further that the minimum qualification of a teacher referred to in the first proviso shall be acquired within the period specified in this act or under the right of children to free and compulsory education Act 2009. So, regulation for the center, এই কোন এখন কাগজ খন যে প্রিন্টেড কাগজ এখন আছে তলব কন্ট্রোল এনইসি হ্যাঁ হ্যাঁ কপি for the acts, central acts, all these three acts, they do not spell out too many things. It is basically the ordinances and the regulations framed under these three respective central acts, which speak up in detail. And if it is repugnant to those also, it will amount to repugnancy to the act itself. Lordship, may I have a look at delay? This is below.
Yes.
National Council for Teacher Education notification. It is of 2014 notification. And actually, why I said the repugnancy, I mean, 2011 Act, it was taken up for hearing 2016. So by in between that, this notification came. So, but there was no occasion to discuss all these things. Discussed immediately there was a concession by the court said department. But in absence of such situation, I think we'll have to go in detail and your lordships will be required to go in detail. In exercise of powers conferred under here. In exercise of powers conferred under clause DD of subsection 2 of section 32 read with section 12A. Here 12A is mentioned. Of the National Council Teachers Education 93 and in supersession of Council for Teachers minimum qualification of recruitment teachers of 2001. That was the earlier one. Except as respects things done or omitted to be done before such supersession, the council hereby makes the following regulations. These regulations will be called National Council for Teacher Education Determination of Minimum Qualification for persons to be required as education teachers, physical education teachers, pre-primary, primary, upper primary, secondary, intermediate schools or colleges regulation. Next page, applicability. Top. These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school imparting pre-primary, primary, upper primary, secondary or senior secondary or intermediate schools or colleges imparting senior secondary education. And then 4 qualification for recruitment. The qualifications for recruitment of teachers in any recognized school imparting pre-primary, primary, upper, secondary, senior secondary, intermediate, or colleges imparting senior secondary education shall be given in the first and second schedule annexed to these regulations. Now the schedules are quoted below. Lordship will go to the next page 167.
Yes.
The first schedule, the boxes for preschool, nursery, primary, upper primary, and secondary up to class 12. Here also, first schedule also it says graduate, postgraduate from recognized university, at least 50% marks in either graduation or post-graduation or equivalent and bachelor. Then the next page, 167, says serial number 5, senior secondary for class 11 to 12. Then the second schedule. Second schedule is starting from primary. Losima, kindly go to page 168 below. Senior secondary. So Bachelor of Physical Education, BPE, Bachelor of Science, or these are or. Either or. %. So it prescribes the minimum qualification. If it prescribes the minimum qualification, Lordship may go to the extent of questioning the government that how can you then dare to appoint unqualified teachers in the nomenclature as a tutor? Maybe a situation, since your Lordship desired that I make certain submissions about the repugnancy if it could be. Then also, my lord, Lordship may have a look at the UGC regulation of 2010. These are the parent provisions.
These are all education ultimately is a subject to concurrent list.
Yes.
Entry 63, is it?
You state can. State can. Both the central can and state can. The entries are one is 25 and one is the other entry. But when you make, it must not be incompatible with the central act. My lord, I am reading the constitution. I am reading 256. Also.
Just for a minute, can we just have a look at the entries in the constitution?
Yes, 256. 256. Yes. (254).
254 is in case of repugnancy.
In case of
But
repugnancy.
let us see the entry first.
Lordship?
Let us see the entry, relevant entry in the
Entry.
concurrent list.
Entry, your Lordship will have to go to concurrent list and entry 26. 25 of the list 3. Education, including technical education, medical education, and universities, subject to the provisions of NT 63, 64, 65, 66 of list 1, vocational and technical training of labor. This is in the concurrent list.
So
Then-
entry 25 in the list deals with
In the
all
co-
types of education.
Yes, in the concurrent list, NT 25 concurrent list.
All right, now let us see 254.
Yes. And it says subject to the provisions of 63, 64 of the list 1, union list. Now let us see 63, 64, 65 of the union list. 63, institution known as the commencement of the constitution as the Banaras Aligarh Delhi University, so and so. 64, scientific and technical education financed by Government of India. 66, professional, vocational, technical training, including training of police, promotion, so and so, so and so. Then it's 66, coordination and determination of standards in institutions for higher education or research and scientific technical institute. This 66 entry in the union list will be very relevant because the power to it is about the power to determination of standards in institutions, higher education. It empowers the central government to legislate. Now, my lord, coming to 254, the language is inconsistency 254. Inconsistency between laws made by Parliament and laws made by the legislatures of a state. If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then subject to the provisions of the clause 2, law made by Parliament, whether passed before or after the law made by the legislature, or as the case may be, the existing law shall prevail and the law made by the legislature of the state to that extent of repugnancy be void. Meaning thereby that if at the same time, at different points of time though, on the same subject, the central government, the Parliament enacts a law, and it is not which the Parliament is competent to enact. Whether passed before or after the law made by legislature of such state, the Central Act will prevail and the State Act covering the same will be void. 2, where law made by the legislature of a state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then laws made by the legislature of such state shall, if it has been reserved for consideration of President and has received his assent, will prevail in that particular state. Whether Kerala makes one, Assam makes one, it will not be, the Kerala Act will cover only the territorial jurisdiction of Kerala only. Others will abide by the Central Act. State of Assam can also make one, provided it is reserved for consideration of the President and his assent is received, my lord, which is not done in the case, even otherwise. It will have. No petition. 207.6.
So 2017 Act obviously has not received the assent of the president. It was not reserved for that.
They did. Day one I saw. I've shown it to you also.
Yes. So you wanted to show something from the
Yes,
UGC
yes.
regulations.
Now come to page 217 of my petition, the educational and professional qualification of teachers.
Page 100 and
217, 217.
yes.
The services of teachers in a venture educational institution from primary level up to degree level shall be considered for provincialization in the post of teachers or relevant teaching faculty in appropriate nomenclature. Hereby, they have kept in their hand, the state has kept it in hand to appoint somebody who doesn't fit in to the central scheme and the central act or even the Guwahati University Act to put them in service with a different nomenclature. As the case may be, subject to fulfillment of eligibility relating to educational professional qualifications as laid down by the rules. Here they may mention, because earlier 2011 Act, these things were not mentioned and the entire act was held to be invalid. Therefore, this time, apparently they have referred to the right of education children, the NCT Act, etc. But in practice, in framing the other provisions, they have gone against them. So the tutor has never been provided for in the regulations under NCERT Act or the UGC Act and regulation,
So
nor the Guwahati.
Rule 6(1) essentially means that right from the level of primary school to degree level, any teacher who fulfills the educational requirement norms laid down by these acts, either the RTE Act of 2009 or NCT 1993 or the other acts mentioned, will be eligible for being a
They'll be eligible for provincialization as teachers. Teachers, simply as teachers.
as teachers.
MA with requisite percentage, net slate,
But
or PhD
this
teacher.
6(1) does not have a non-obstantive clause. So are you suggesting that by 6(1) on one hand, there is again a conferment of eligibility,
My lord, here,
which is taken away by 3(1) sub-rule 1 proviso? Is that the argument you're making?
you cannot, with this nomenclature, you are.
We are not about the nomenclature, we are about provincial election.
2005 Act में आपको एवं लोग 2005 Act में
No, Mr. Borbora, please clarify on one thing.
Lordship,
We are trying to appreciate your arguments. Under 6.1,
yes,
what it lays down is that from the lowest to the highest level, degree level, any teacher
or
or whatever nomenclature we are.
or relevant teaching faculty. Teaching faculty means one who deals with imparts education and teaches students.
Correct. Who possesses the professional educational and professional qualification laid down under any of these statutes, A, B, C, D, would be eligible for provincialization. That's what it prima facie lays down.
If under these three central acts, one has the minimum qualification as prescribed by it, then why divide them?
And one state act.
Then why divide them into teachers and
No,
tutors?
no, that's what we are asking.
Yes, yes.
So are you projecting an argument of repugnancy on such count? This is
Yes.
number one.
It may be made.
Number two,
It cannot escape.
are you also assailing this section on the ground that there is no scope to have a category called tutor? Is that also your argument? Or
That-
not?
There is a big question, but
No, if it is there, we would like to ask some clarificatory questions. That's all. If you say yes, then there will be some follow-up questions. If you say no, obviously we are not.
I'll
doing it.
take note of the questions both either way. I'll
Okay.
take note of the questions either way.
No,
But-
why we are asking is 6.2 mentions or deals with tutor.
Hmm.
But it does make provision for provincialization of service of tutors. The distinction is on the basis of qualification. Correct. Now, we are in this act, we are dealing with the process of provincialization. Whichever be the category, the process of provincialization. The state says if you possess these qualifications, teacher, if not, tutor. But both these categories are entitled to provincialization. That is subject to the cutoff rule. That is not in dispute. Do you agree with that?
No, that maybe yesterday Mr. Bora was submitting. I am just assisting your lordships, taking as an assistance. That there may be some harmonious reading and certain provisions may be saved by reading down and all these things. But things may at times come to the extent that there cannot be any compromise with regard to repugnancy. Either you uphold your, or you say no, you cannot do it. Position may come to that extent. Lordship will ask that question to the government. Lordship will say, the term tutor till the other day, this terminology was not there in educational statute. It is
This was
sprung up.
not there under the 2011. It was introduced for the first time in 2017.
No, 11, I think it was 11.
Mr. Majumdar,
5, it was not there.
the expression tutor was there in the 2011 Act.
No, because we did not give any difference between the persons who are being provincialized on the basis of their education qualification was one of the ground why this 2011 Act was held to be unconstitutional. Now, when we took up all the persons who were actually serving in the school, people without qualifications were also serving in the school and people with qualifications were serving in the school. One of the grounds was that you had differentiated between them and made them all teachers. So what we did was we classified one of them as teachers per the NCT or the other acts. The others who did not have the qualifications admittedly were teaching those students. So they come up as tutors. Tutors in the general context means a person who assists a small group or an individual outside the exact curriculum being taught by a teacher. That is the definition which we have found in the
Qualification means they were not
So the-
graduate having BEd degree.
yes, but they were still teaching in those schools. Practically, they were imparting
They
education.
are not graduates or did not have BEd.
Either of the two could have happened. Any of the two could have happened in schools. In colleges, they did not have the required post-graduation or maybe the other qualifications.
Acha, tutor part.
Let us see.
tutor-
Also, my lord,
We are trying to bring into fold the entire, all the people without discriminating because they were already teaching, but we cannot have them as
That's
teachers.
right. Otherwise, you are trying to streamline, there is no doubt about
Yes.
it. But the fundamental fault line here, as would be contended by the petitioner, is that you have abruptly drawn the line, eliminating, excluding about 32,000, 31,000 odd teachers
Yes,
by fixing a cutoff 1/1/2006,
that matter.
which is arbitrary. That's the
That
sum and
is
substance of it.
actually the whole issue in this case.
That's the
The
whole
other, all arguments.
Other-
we can-
other
we can
things
just-
are- maybe subject to what the other
One-
concerns and Mr. Borough. Other things do not appear to be all that serious.
But otherwise,
But,
if we don't give
this-
it as teacher tutor.
Arbitrary cutoff, and then the argument that when your object says this is to
Streamline the whole thing.
streamline, provincialize, and stall the mushrooming of venture schools.
Yes.
There is nothing in the act which stalls the mushrooming of venture schools. You just decide that with effect from this date, we are not going to grant permission, provincialize, or even permissions granted retrospectively, we will not take cognizance. But at the same time, more schools are being granted permission and recognition.
So, my lord, where the government will draw a line between schools which seek to be under the government, which seek all the help from the government to survive or to teach, and schools which do not seek such and remain established as private establishments. They make their own funding, we just regulate the fees.
So
They
those
make the-
schools and the non-government educational institutions recognitions under that act.
We are giving. We will give if they fulfill all the
They
conditions.
will
CBSE
never be
says
provincialized.
they will never be provincialized. That is one of the conditions for the recognition. That you will not come to the government asking for anything. You cannot run it, you shut it down. Those who say that we are doing a service and only,
So is there any figure? Can you tell us how many teachers had suffered due to this cutoff 1/1/2006? When the 2017 Act was.
that would include participation of three departments, the elementary education, the secondary education, and the higher education also.
Mhm.
So it may take some time, but we'll do our best to have that
But that data is
quantification.
with you. It
My
says
lord,
under
no,
the school
when-
education,
when-
Department of, now you give it the name, Department of School Education.
No, that is elementary and secondary, but those schools which remained elementary, they are also under the Department of School Education, but and those who were only secondary education, they also remain thus. Then the amalgamations, those are things we can take care of. But when on Lordship's question, there were schools who could not even apply and are before Lordship. So we cannot say about those people. Only those people who applied, we rejected
Those who could not
under
apply,
17. That we
they are
can
not
find out.
that.
Applied and
Here, the fundamental and the most important question is, what happens to those, because your provision of your 2011 Act itself says, those who are provincialized or are going to be provincialized.
Under the Act.
Under
That
the
that
Act.
sentence is there.
Yes. So when this Act was enacted,
Yes,
some got the provincialization. For others, it was work in progress,
yes,
correct?
yes.
Many out of them also got the recognition. But it came in some cases, it came in before 1/1/2006. Some cases, it came in after 1/1/2006, but with retrospective effect. So you put a wedge between these categories and say that, sorry, we don't know who you are. Correct.
Yes.
So it is on that context, this provision of 311 has been essayed.
SL, yes.
On the ground that it is unconstitutional, it is hit by the philosophy of equality enshrined under Article 14. That's the primary argument.
Reasonable nexus being.
If that argument is accepted and the provision is either struck down or read down or whatever it is, then the next question would be, would it have any bearing on the other provisions of the Act?
And
Or even if it is read down or struck down, whether the Act is capable of being implementation? That, as we understand, will be in the sphere of examination by the court insofar as the constitutionality of the Act is concerned. We are not really so much into what right has been conferred or denied to someone under the Act or wrong application of administrative power. These are
That's
not
not-
going to be the subject matter of scrutiny here. Similarly, in case of tutors, the government, of course, we have not heard the arguments in that, but prima facie, the government can have intelligible differentia to classify people.
Yes.
So intelligible differentia here would be that people with the qualification,
Qualification without the
people without the
without the
qualification.
qualification.
Prima facie, this tutor-teacher divide, prima facie appears to be not violative of the
Why,
Constitution.
what, from what we went through the repetitions, we found that the the classification as a tutor has been assailed only on the ground that people without those qualifications were provincialized under the 2011 Act as a teacher. But when the,
So, Mr. Majumdar, if you don't mind, we would like to encroach a little on your lunch,
yes, there's no,
lunch
no,
routine.
no difficulty,
Can you, in a piece of paper,
my lord.
give it to us in all these 82 writ petitions?
Mm.
Which are the broad categories of petitioners? What are the categories? One category is that those who establish their schools
Yes.
with permission prior to 1/1/2006. But the permission was accorded with retrospective effect by issuing notifications after 1/1/2006.
Yes.
That's one category. Likewise, which are the other categories? So how many categories of of aggrieved persons are there in this batch of writ petition?
And
You could just-
here will be two things. Once, those venture educational colleges, the concurrence given by the government,
Hmm.
and prior to 2006, who have been affiliated by the jurisdictional universities.
So could you also?
No, I
ask us
know
to
about
give-
my case. All these I cannot.
No, from your side, if you want to give, your juniors can give us in pics.
No,
We'd like to start working on the,
my colleges are, my lord, they started, my lord, prior to 2006.
you started prior to 2006, got the affiliation from the Guwahati University, Dibrugarh University.
And the appointments were from 1999 to 2010. 2010 is the last petition.
But they were denied provincialization on the ground that, first ground was that the additional post.
Additional post number one, and number two, 2006 shutters down. 2006, from 2006 shutters down.
So, can you please put it in a piece of paper in these petitions and give it to us that these are the, this is the category and this is the grievance, just in one page.
That, my lord, if there are 49 petitioners, I think he can do it in
Monday.
like during lunch hour and half an hour, 20 minutes.
All right.
Now, my
We
lord,
had made a compilation, I'll try to place it. We had made a compilation on the nature of the challenge, not
We
regarding.
want it in half a page.
No, no, here are the affidavit in opposition also, but otherwise, my lord, the classification is just small paragraphs. This is the list of the cases which deal with that particular ground, and this is the
There are
challenge.
5 or 6 categories.
six,
of-
only six. We have made it,
That
we
means
have made
it's
it
a
5.
half a page.
5. So I'll just cut down this and put it up in one page. It's yes.
One page maximum.
I'll do it right now. I can do it right now.
about the query put by to me by your lordship about the details, I think in my petition, already a chart is there, annexer 1. Will that do, my lord? Page 200.
Page 200.
Yes, my lord. Here, my lord, every petitioner's name is given,
Hmm.
subject is given, and who joined when, it is also given, my lord. The names are there.
Yes.
Who joined when, that is also given, like 2007, one is 99. Then another is 99, then 2001, then 2001.
Okay.
1, 2, 3,
All right.
4. So that will do, I think.
Yes.
So more than this, my lord, it will be difficult.
No, it's all right.
Okay. So that will suffice, it will be.
Yes.
And then one more thing I was, my lord, the UGC regulation on minimum qualifications for appointment of teachers and other academic staff in universities and colleges
Mhm.
and measures for maintenance of standards. 30th June 2010, my lord. This I have given.
Yes.
My lord, this was issued in exercise of, my lord, section 26 of the UGC Act.
Mhm.
And here, your lordship, next page of the forwarding letter circulation. 2 says the minimum qualifications for appointment and other service conditions of the university and college teachers,
Yes.
librarians and directors of physical education, sports, measure for maintenance of standard higher education shall be as provided in the annexure to this regulation.
Yes.
Now the annexures are here. First annexure, your lordship will find these regulations are issued for minimum qualifications for appointment and other service conditions of university and college teachers, librarians, so and so in higher education and revision of PIC. Then next page 3.0.0 recruitment and qualifications are given. 3.3.0 below and 3.3.1. It talks about net select. It talks about master degree percentage of marks. Then next page talks about direct recruitment, professor, qualification of principal, associate professor. Then next page, my lord, arts, humanities, science, social science, commerce, education, language. Net select shall also not be required for such master programs in disciplines for which net select is not conducted. So, my lord, in a way, UGC also lays down the minimum qualifications and net also. So these two Central Act is complementary to each other, supplementary to each other. They are not at loggerheads. But this Act state, without even receiving, my lord, the assent of the president, has postulated certain things. So, my lord, the way it was, my lord, legislated, prescribing different provisions, it will be a very hard touching stone to adjudicate. The realities are always hard at times. Truth is always harsh. If you call it a truth, call it a truth. If it is not, then it is not. We may be in a position like this. Earlier it was held to be invalid. Maybe this time also your lordship will be required to hold it to be invalid, but this time, after detailed discussions of clauses, certain clauses, giving an indication, not directly court's indication, that for these, we are finding them to be unconstitutional. So that next time, within 6 months or 1 year, if they come up with a new legislation, they will be reminded by the judgment, which was not done earlier. All right. Now on repugnancy, my lord, I'll conclude by, my lord, just referring to 3 or 4 decisions. I think it will be over in 15 minutes. 1979, volume 3 is 5 judges. SCC 431. This famous Karunanidhi, M. Karunanidhi
Yes.
of Tamil Nadu versus Union. This decision was on the Tamil Nadu Public Men Criminal Misconduct Act 1973. I will refer to paragraph 7. We propose to deal with paragraph 7.
Yes.
We propose to deal with the 2 arguments separately. We would first deal with the question of repugnancy as raised by learned counsel of the appellant. It's true that the state act was passed by the legislature of Tamil Nadu and the assent of the president was obtained. By virtue of the provisions of 254(2) of the Constitution, since the assent of the president had been given, the State Act was to prevail over the Central Act so far as the state of Tamil Nadu was concerned. Leverages are either way. But the serious question to be considered is as to whether or not there was a real repugnancy resulting from irreconcilable inconsistency. Then Article 254, the text is quoted here. Then, Your Lordship, paragraph 8, it would be seen that clause 1 of 254 is concerned, it clearly lays down where there is a direct collision between a provision of law made by the state and that made by the parliament with respect to one of the matters enumerated in the concurrent list. 25. Then, subject to the provision of clause 2, provisions of clause 2, where it is mentioned, existing law was mentioned, the state law would be void to the extent of repugnancy. This necessarily means that where both the state and the parliament occupy the field contemplated by the concurrent list, then the act passed by the parliament, being prior in point of time, will prevail, and consequently the state act will have to yield to the central act. In fact, the scheme of constitution is a scientific, equitable distribution of legislative powers between parliament and state legislature. First, regarding matters contained in list 1, that is the union list, to the 7th schedule, parliament alone is empowered to legislate and state legislatures have no authority to make any law in respect of entries contained in list 1. That is always. Secondly, so far as the concurrent list is concerned, both parliament and state are entitled to legislate in regard to any of the entries appearing therein, but that is subject to the condition laid down in Article 254(1) discussed above. Thirdly, so far as the matter of list 2, that is the state list, are concerned, it doesn't arise here. Then 1 to 3 circumstances, it is therefore obvious that in such matters repugnancy may result from the following circumstances. These are the principles laid down by 5 judges. Where the provision of a central act and a state act in the concurrent list are fully inconsistent and are absolutely irreconcilable, of the central act will prevail and the state act will become void in law. Inconsistent, certain impugned provisions herein, if they are found to be inconsistent, then also the repugnancy will come, not essentially the entire impugned act. Where, however, a law is passed by the state comes into collision, this is yet another word. There the word was inconsistent, here the word is collision. With a law passed by parliament on an entry in the concurrent list, state act shall prevail to the extent of repugnancy and the provisions of the central act would become void, provided the state act has been passed in accordance with clause 2 of Article 254, requiring presidential assent. Requiring presidential assent. In that particular state, it may be operative, provided you take presidential assent. Where a law passed by state legislature while being substantially within the scope of entries in the state list entrances upon, and the entries in the central list, the constitutionality of the law may be upheld by invoking the doctrine of pith and substance. Is on analysis of the provisions of the act, it appears that by and large, the law falls within the 4 corners of the state list, and entrancement, if any, is purely incidental and inconsequential. In our case, there are multidimensional consequences. Future bleak. Having served for 20 years, 25 years with all requisite qualifications, retire without being provincialized. 4, however, a law made by state on a subject covered by concurrent list is inconsistent with and repugnant to the previous law made by parliament, such a law can be protected by obtaining the assent of president under. So this cannot be protected here also. Well, by 2018, you are providing for certain provisions which apparently may be inconsistent with some of the provisions. But in that case, you take the assent of the president. The result of obtaining assent of the president would be that so far as the state act is concerned, it will prevail in the state and overrule the provisions of the central act in their applicability to the state only. Such a state of affairs will exist only until Parliament may at any time make a law adding to or amending, varying, repealing the law made by the state under not for years. So this is taking the assent is the vital postulation that gives prevalence of your legislation or the operation of your legislation in the state of Assam, irrespective of certain inconsistencies and collision with the center. But it cannot happen now. The greatest mistake they have done was not to send it to the president for assent. Hurriedly made. Governor is nearer, get his assent. Then various studies of constitutional validity, same under article, so and so. Then, my Lord, may say to come to paragraph 33. In case of state of Odisha, this is 1964 case. Repugnancy arises when two enactments both within the competence of two legislatures collide, and when Constitution expressly or by necessary implication provides that the enactment of one legislature has superiority over the other, then to the extent of repugnancy, the one supersedes the other. But two enactments may be repugnant to each other, even though obedience to each of them is possible without disobeying the other. I think what he was arguing well, Mr. Bora, I was listening from read down the provision, save it. Otherwise, all of us are gone. That's sort of a harmonious reading of both the 93 Act and this provision there and there. Here, there is leverage, but the two enactments may be repugnant to each other, even though obedience to each of them is possible without disobeying the other. The test of two legislation containing contradictory provision is not, however, the only criterion of repugnancy, for if a competent legislature with a superior efficacy, expressly or impliedly, evinces by its legislation an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne on the ground of repugnancy. Where such is the position, the inconsistency is demonstrated not by a detailed comparison of provisions of the two acts, but by the mere existence of the two pieces of legislation. Then paragraph 34. In case of is 69 case, it was pointed out by this court that before coming into the conclusion, there is a repeal by implication. This court must be satisfied that the two enactments are so inconsistent that it becomes impossible for them to stand together. In other words, this court held that when there is a direct collision between the two enactments, which is irreconcilable, then only repugnancy results. In this connection, court made the following observations. Before coming to conclusion that there is a repeal by implication, the court must be satisfied that two enactments are so inconsistent or repugnant that they cannot stand together, and the repeal of the express prior enactment must flow from necessary implication of the language of the latter amendment. It is therefore necessary in this connection to scrutinize the terms and consider the true meaning and effect of two enactments. These provisions of 1922 Act do not alter the nature or quality of the offense enacted under, but it merely provides a new course for procedure for what was already an offense. Can Losime come to paragraph 35? This is the last paragraph of this judgment I am citing. On a careful consideration, therefore, the authorities referred to above the following positions emerge. That in order to decide the question of repugnancy, it must be shown that the two enactments contain inconsistent and irreconcilable provisions so that they can stand together or operate in the same field. That there can be no repeal by implication unless the inconsistency appears on the face of the two statutes. That while the two statutes occupy a particular field, but there is room or possibility of both statutes operating in the same without coming into collision each other, no repugnancy. That where there is inconsistency, but a statute occupying same field seeks to create distinct and separate offense, no question of repugnancy. So these are the positions, and I will, my lord, go to the 2 or 3 subsequent decisions.
Continue at 2.
Hardly 15-20 minutes. I'll continue.
And
Replying to
then-
some more decisions.
You are also appearing in some other writ petitions also.
I am appearing in my lord group that is not there, where my lord, I will try to say, are being provincialized, that word. Your lordship should not be perturbed by the review courts, what the review court said. That was in a closed circuit.
Yes.
Come to that.
Yes, please.
Please, my lord, resuming. I now have Karunanidhi's case I have referred to. Next, my lord, another case, 5 judges, State of Kerala. 2012,
Yes.
2012, volume 7, SCC. Page 106.
Yes.
Here, my lord, the 5 judges, including the then Chief Justice Supreme Court. The issue before was, my lord, the repugnancy and Chit Fund Act.
Yes.
And here the repugnancy was discussed that some threadbare earlier decision was also discussed. I will take your lordship straightway to paragraph 40. This paragraph online this.
Yes, paragraph 14.
Being an all-timer.
Switch off.
Yes, my lord.
Yes, paragraph 14.
Yeah, being an old-timer, my lord, orthodox, I always love to read from books, my lord.
Yes, yes.
Yes, these books have my own marks.
Yes, yes.
Yes. My paragraph 40. However, the principle of federal supremacy in Article 246(1) cannot be resorted to unless there is irreconcilable conflict between entries of the union and state list. The said conflict has to be a real conflict. The non-obstante clause in Article 246(1) operates only if reconciliation is impossible. As stated, the parliamentary legislation has supremacy as provided under 246(1) and 246(2). Let us for a while see, my lord, 246(1) and 2. The court's not there. The language. While dealing with 254.
Uh, 246.
246. Subject matter of laws made by the parliament and by the legislatures of the state. Notwithstanding anything in clause 2(3), parliament has exclusive power to make laws with respect to any of the matters enumerated in list 1. 2. Notwithstanding anything in clause 3, parliament and subject to clause 1, the legislature of any state also have power to make laws with respect to any of the matters in list 3. Then 3, subject to clause 1 and 2, legislature of state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in 7th schedule. Parliament has power to make laws with respect to any matter for any part of the territory of India not included in the state, notwithstanding that such matter is a matter enumerated in state list. This is in overriding provision. So this is the language of my lord 246. Here, my lord, in paragraph 40 again, Kerala case. However, the principle of federal supremacy so and so, this said conflict has to be real conflict. Non-obstante clause in Article 246(1) operates only if reconciliation is impossible. As stated, the parliamentary legislation has supremacy as provided in 246(1) and 2. This is of relevance when the field of legislation is in the concurrent list. The union and state legislatures have concurrent power with respect to subjects enumerated in list 3. Hence, the state legislature has full power to legislate regarding subjects in the concurrent list, subject to Article 254(2), that is provided the provisions of the state do not come in conflict with those of the Central Act on the subject. Thus, expression subject to in clause 2 and 3 of Article 246 denotes supremacy of Parliament. Then I take your lordship to paragraph 47. The question of repugnancy between parliamentary legislation and state legislation arises in two ways. First, where the legislations, though enacted with respect to matters in their allotted spheres, overlap, here the word is overlap, and conflict, conjunctive, when it overlaps and also in conflict. Second, where the two legislations are with respect to matters in the concurrent list and there is a conflict, only conflict. In both these situations, the parliamentary legislation will predominate. In the first, by virtue of non-obstante clause in Article 246(1), that amounts to, my lord, as it is conditioned by 254(2), by reason of Article 254(1). Then, my lord, paragraph, I'll go to paragraph 78 of the judgment. 78,980. The conclusion of their lordships. 78. To sum up, 246(1), 2 and 254(1) provide that to the extent to which a state law is in conflict or which or repugnant to Central Act law, which Parliament is competent to make, the central law shall prevail and the state law shall be void to the extent of its repugnancy. General rule of repugnancy is subject to 254(2), which inter alia provides that if a law made by a state legislature in respect of matters in the concurrent list is reserved for consideration by the President and receives his or her assent, then the state law shall prevail in that state over an existing law or law made by the Parliament, notwithstanding its repugnancy. Assent of President, crucial. 79. Provision to 254(2) provides that a law made by the state legislature with the President's assent shall not prevent Parliament from making any law. That is for Parliament, my lord. Thus, Parliament need not wait. Coming to 80. Lastly, the definitions of expressions laws in force in Article 13(3)(b) and Article 372(3), explanation 1, and existing law in 366(10), so that the laws in force include laws passed or made by a legislature before the commencement of the Constitution and not repealed. Here, my lord, pausing for a while, I am again referring to Article 13(3) in the context of repugnancy. What law means for the purpose of repugnancy? Article 13. Yes. 13 says it is head is laws inconsistent with or in derogation of the fundamental rights. All laws in force in the territory so and so. The state shall not make any law which takes abuses rights. Then 3 is important. In this article, unless the context otherwise requires, the law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Laws in force include laws passed by or made by legislature or other competent authority in the territory of India before commencement of this Constitution and not previously repealed, notwithstanding that any such law or part thereof may not be in operation either at all or in particular areas. Now, this is important because when I say that it is repugnant to the basic parent act itself, if it is repugnant, inconsistent, or in conflict with any of the regulations framed under the parent act, that will do. That is law. Any ordinance or statute, I refer to the statute of the Dibrugarh University and Guwahati University, my lord, that day. And here again, the existing law before the commencement of the constitution, Guwahati University Act, my lord, 1948, before the coming into being of the commencement of the constitution, it was a provincial act. At that time, the provincial act under Gopinath Bordoloi. So even then it exists. 1948 act, before the commencement of the act. Now you are enacting an act after 70 years, which goes against and in conflict with the Guwahati University. And that also you are doing without the presidential list. That is the additional name in this case. Central Act plus Guwahati University and Dibrugarh University. Dibrugarh University Act is of course 1965, 4 Act. Then, my lord, laws made by legislature, let me finish this paragraph 80. Laws in force include laws passed or made by legislature before the commencement of the constitution and not repealed, notwithstanding any such law may not be in operation at all. Thus, the definition of expression laws in force in Article 13(3)(b) and 372(3) explanation 1 and definition of expression existing law in 372 and 366 also spells about my existing law as it is, my lord, spelled in 13(3). And the definition of the expression existing law in Article 366(10) demolish the argument of State of Kerala that a law has not been made for the purpose of 254 unless it is enforced. Expression existing law finds place in Article 244. Then it makes a reference to a decision of 1950. The next case will be, my lord, 2006, Volume 9. Yeah.
Yes.
2006, Volume 9, SCC, page 1.
Yes.
State of Maharashtra versus so and so, Shikshan Shastra Mahavidyalaya. Here, my lord, I will take your lordships to paragraph 52. Paragraph 52 and a few paragraphs. Paragraph 52, the same principle was applied to University Act and the court held that after coming into operation of the Central Act, here the University Act came like. University Act would be deemed to have become unenforceable in case of a technical colleges. It was observed that the provisions of the University Acts regarding affiliation and technical colleges and the conditions for grant of continuation of such affiliation university would remain operative, but the conditions that are prescribed by the university for grant and continuation of affiliation must be in conformity with the norms and guidelines prescribed by the council. Here our Guwahati University is not in conflict with my lord NET Act or UGC Act. Here in this case, my lord Maharashtra case, it was. The court then considered the arguments put forward on behalf of state that while it would be open for a council to lay down minimum standards and requirements, it didn't preclude the state from prescribing higher standards and requirements. Negating the contention, the court quoted with the approval of following observations. Let's may skip this. Paragraph 55. Reference was also made to a decision of this court in Gokul Education Trust, relying on Adhin and reiterating principle laid down therein. Court held that once the field was occupied by an act of parliament, the state could not have made a statute inconsistent with the provisions of the central legislation. Court therefore held that even if there was a state law which required something to be done for approval of the state government for establishing a technical institution, such law, if it is inconsistent or repugnant with the central law, it would be void to the extent of repugnancy to the act of parliament. 56. In that case also, like here, the state government sought to support its action of not permitting new engineering college to be established on the ground of policy. It was stated by the state of Kerala that it would not permit establishment of any more engineering college in the state in view of large number of already existing colleges bearing in mind the interest of the students and the employment condition. Relying the Adhiyaman, it was observed that so-called policy of the state government as mentioned in the counter affidavit would not be made a ground for refusing approval. Lordship may take it also as a citation by me in respect of my earlier argument about the policy of the government, the irrational policy, my lord. It will fit in there also. Court held that essentiality certificate cannot be withheld by the state government on any policy consideration because the policy in the matter of establishment of a new college rested essentially with central government. Then another is a quoted Jaya Gokul Enterprise case. Our attention was invited to the Tamil Nadu case. There is the question of repugnancy between provisions of Indian Medical Council Act and the Tamil Nadu Medical University Act, renamed as MGR Medical University, Tamil Nadu. Notes may come below 60, paragraph 60. Referring to relevant provisions of the Constitution of both the acts and relevant case law on the point, court observed that the question which had arisen before the court was as to the role of state government in the matter of establishment of new medical college. 61. Interpreting the statutory provisions, court held that by enacting section 10A of that act, Parliament had made a complete and exhaustive provision covering the entire field of establishing of new medical college in the country. No further scope is left for the operation of state legislation in the said field, which was fully covered by the law made by Parliament. Court therefore held that the proviso to subsection 5 of section 5, which requires prior permission of state government for establishing medical college, was repugnant to section 10A of the Central Act, and to the extent of repugnancy, state act would not operate. Court noted that in the scheme that had been prepared under the regulations for establishment of new medical colleges, one of the conditions for qualifying criteria laid down was essentiality certificate regarding desirability and of having the proposed college at the proposed location, which should be obtained from the state government. The proviso to subsection 5 therefore must be considered only as regards proposed location. The essentiality certificate, however, could not be withheld by the state government on any policy consideration, in as much as policy and the matter of establishment of new medical college rested with the central government alone. From the above decisions, in our judgment, the law appears to be very well settled. So far as coordination and determination of standards in institutions for higher education or research, scientific technical institutions are concerned, subjective exclusively covered by entry 66 of list 1. And the state has no power to encroach upon legislative power of Parliament. It is only when the subject is covered by entry 25 of list 3 that there is concurrent power of Parliament as well as the state legislatures, and appropriate act can be made by the state legislature subject to limitations and restrictions under the Constitution. Not absolutely free. It is conditioned by the limitations of Constitution, including my lord 254. 63, in the instant case, admittedly Parliament enacted 93 Act, which is in force. Preamble provides for establishment of NCTE with a view to achieving planned and coordinated development of teacher education system throughout the country, the regulation and proper maintenance of norms and standards in the teacher education system, and for matters connected therewith. With a view to achieving that object, National Council for Teacher Education has been established at 4 places by central government initially. It is thus clear that the field is fully and completely occupied by Act of Parliament covered by entry 66. It is therefore not open to state government, state legislature to encroach upon the said field. Parliament alone could have exercised the power by making appropriate law. In these circumstances, it is not open to the state government to refuse permission by relying on a state act or on policy consideration. Then 71. It's not necessary. It's going into the detail. Main postulations are there. Then, my lord, paragraph 73, it talks about secondary education also. Paragraph 74, it is thus clear that the central government has considered subject of secondary education and higher education at the national level. Act of 93 NCT Act also requires Parliament to consider teacher education system throughout the country. NCT therefore, in our opinion, is expected to deal with applications for establishing new B.Ed colleges and allowing increase in intake capacity, keeping the view the 1993 Act and planned and coordinated development of teacher education system in the country. It is neither open to the state government nor to a university to consider the local conditions of apply state policy. So, my lord, it is seen that court, including Supreme Court, is also of the view that there should be homogeneous national standards, and therefore nowadays the common entrance test net, they highly debated yesterday, day before yesterday, that is held for all medical colleges. So the ambition is, had this been a legislation to, my lord, supplement such things, then it would have been a different hit, but it is sabotaging such things. Next. This is, my lord, 2013 volume 2 SCC. Volume 2 SCC 617.
Yes.
Mahavaishno Mahavidyalaya, State of UP. Here, my lord, I will refer just two paragraphs. Paragraph 59. Paragraph 59. The above enunciated principles clearly show that the council is the authority constituted under Central Act with the responsibility of maintaining education and standards and judging upon the infrastructure and facilities available for imparting professional education. Its opinion is, let's may skip and come slightly below. The state can frame its policy or admission to such professional courses, but such policy again has to be in conformity with the directives issued by the central body. In the present cases, there is not much conflict on the issue, but it needs to be clarified that while state grants its approval and the university its affiliation for increased intake of seats or commencement of a new course, new college, its direction should not offend and be repugnant to what has been laid down in the conditions for approval granted by central authority of council. What is more important is that all these authorities have to work ad idem as they have a common object to achieve, that is of imparting of education properly and ensuring maintenance of proper standards of education, examination, infrastructure for betterment of the education system. Only if all these authorities work in a coordinated manner and with cooperation will they be able to achieve very object for which these entities exist. Then paragraph 60, the NCT Act has been enacted by Parliament reference to Schedule 66. There is no such specific power vested in state legislature under NT 25 in relation to education, including tackling and education, so and so in education, universities, vocational, technical. Field is primarily covered by a union list, and the state can exercise any legislative power under 25, but such law cannot be repugnant to the central law. Whether the state law is irreconcilable with the central law, the state law must give way in favor of central law to the extent of repugnancy. This will show the supremacy of the central law. Then it quotes from, my lord, the Medical Council of India case. So the earlier Maharashtra case has also been quoted in this Mahavaishnu case, my lord. So I will not repeat those. Then, my lord, I will take your lordship to 1995 volume 4 SCC, is again a Tamil Nadu case. Tamil Nadu case 2104. Here I will go, my lord, to straightway to paragraph 43. The broad principles are there, conditions. 43. This is the conclusion. What is called coordination? What is conflict? These are the basic postulations my lord embodied. 43. What emerges from the above discussion is as follows. 1. Expression coordination used in entry 66 of the 7th schedule. It means harmonization with a view to forgive a uniform pattern of a concerted action according to certain design, scheme, or plan of development. It therefore includes action not only for removal of disparities in standards, but also for preventing the occurrence of such disparities. It would therefore also include power to do all things which are necessary to prevent what would make coordination either impossible or difficult. This power is absolute and unconditional, and in the absence of any valid compelling reasons, it must be given its full effect according to its plain and express intention. 2. To the extent that the state legislation is in conflict with central legislation though the former is purported to have been made under entry 25, but in effect encroaches upon legislation, including subordinate legislation made by the center under entry 25 of the concurrent list, or give effect to entry 26, it would be void and inoperative. Then, if there is a conflict between two legislations, unless the state legislation is saved by the provisions of the main part of clause 2 of article 254, the state legislation being repugnant would be inoperative. 4. Whether the state law encroaches upon entry 66 or union list, or is repugnant to the laid by the center under entry 25 concurrent list, will have to be determined by the examination of two laws and will depend upon facts to facts. When there are more applicants than available situation seats, the state authority is not prevented from laying down higher standards for qualification than those laid down by the center or central authority to shortlist the applicants. When the state authority does so, it does not encroach upon entry 66 or make a law which is repugnant to the central law. However, when the situation seats are available in the state authorities deny an applicant the same on the ground that the applicant is not qualified according to its standards, as the case may be, although the applicant satisfies the standards or qualification laid down by central law, then they act unconstitutionally. So also when the state authorities de-recognize or disaffiliate an institution for not satisfying the standards of requirement laid down by them, although it satisfies the norms of requirements laid down, norms and requirements laid down by the central authority, the state authorities act illegally. Then paragraph 45. As a result, as has been pointed out, the provisions of the central statute on the one hand and state on the other being inconsistent and therefore repugnant, the Central Act will prevail and the de-recognition by the state government or the disaffiliation by the state university on grounds inconsistent with road enumeration enumerated in the Central Statute will be inoperative. So I am almost concluding, just to summarize, my lord. Number one, the provisions, this provision, clause 3, clause 4, clause 8, are as provisions, as sections, there can be requirement. If the act as a whole is not, then provisions are arbitrary, irrational, discriminatory, and harping on unreasonable classification. This is what this act has made, my lord. I have been submitting. Then, your lordship, it doesn't have any nexus, intelligible difference, no nexus with the objects of the act. And for objects, Supreme Court has said that we have to go to the history of the state act. I'm sorry. A state of the history of the enactments for looking at the object. The concept of provincialization of venture teachers in Assam starting from 1977. This act came, that was annulled, that was repealed. Again, this act comes. The history, therefore, is very important for your lordship to go into. 2011 Act, since repeal, and the case, there was no discussion at all on individually on the offending and infringing categories. Because there was no occasion. And here, as against the earlier division bench, exercised by the earlier division bench. Here the exercise by your lordship will have to be definitely far more, because there is no concession coming this time, admitting anything. So on merit, every section and clauses on the basis of my humble submissions, as may be subject to the what they reply, my lord, not before that. Your lordship you will have to hold. And then whether these provisions are irreconcilable with the other acts, if they are, then they cannot be saved or retained. More so in absence of a presidential assent. And then, assuming that act as a whole is not held to be repugnant, striking down so many provisions will attract the doctrine of severability, that the remaining valid parts cannot be saved, because they taken together, they cannot carry forward the objects not to be attained by the act. The whole act will automatically be invalid then. As per 57 Constitutional Amendments. Therefore, my lord, here, my lord, while setting aside, I sincerely believe that the provisions are unseverable, repugnant, act as a whole goes, yes, in a particular state, in a proper manner, state of Assam could have hold by way of a legislation, but having presidential assent and all these things were discussed in all this judgment. That was also not done. Therefore, after discussion, I mean, my part is over now. Your lordship part now starts to, my lord, look at all these things, and if at all decide to set aside the act, then there will have to be a judicial findings on invalidity, or for that matter, various sections, and there will have to be a direction for judge's recommendation. Like the earlier court, it was not discussed. It is called nowadays judicial or not judicial statute. I give an example. 2003 March, for the purpose of appointing Chief Election Commissioner and Election Commissioner, Justice Joseph's judgment. Here, it is a judicial, that in the absence of a law, you are coming with a law, all right. Till then, the constitutional body of Election Commission will have to be there. One election commissioner goes out and the other will have to come. Therefore, constitute a panel comprising Prime Minister, Leader of the Opposition, and Chief Justice of India. In March 2009, it was, my lord, judicial recommendation for an enactment. We expect you to come up with an act with these three. Balancing PM, Leader of the Opposition, and CJI. Unfortunately, in November 2013, 13 months thereafter, Honorable Justice Joseph's judgment.
2023.
2023, November it came. It's a long name, appointment of Chief Election Commissioner of India, tenure, condition of service, etc. Act 2023. Unfortunately, in the panel, what was suggested by the 5-judge Supreme Court was no more there. Only Prime Minister remains, Opposition Leader remains, and 1/3 member, instead of Chief Justice of India, 3rd Justice was to be a person nominated by Prime Minister. So there may be an occasion where your lordship might have to give some recommendations. All right, this you have done bad. There cannot be 150 students. We are making someone additional. This query will be there as well as the provisions on their merit, their validity are considered, whether ultravirus or intravirus or Article 14 validity of Article 14. Definitely they will come to know. That apart, there will have to be some trade pointer, because it has got to do with, my lord, thousands of teachers. Thousands of teachers means, my lord, lakhs of students.
What is the meaning of intravirus, the constitution?
Intravirus means your intravirus means, my lord, from within there are contributions, self-incompatible. Inner contradictions. And ultravirus is with section 5 is ultravirus to section 6, ultravirus to also to the constitution. So with that note, my lord, I'll expect them to come. And Lordship was asking me about the other case. I think I know. Engaged by some other lawyers, my lord, I was not there. I will come again. It is in group 20. Here, my lord, actually is Goswami or good that case. Here, my lord, what happened? Item given us little. 70. Just for that, it is not comprehensive argument. I will come in. 78 to the auction. 70 is there is my notice there, na? 77, 8, 9. Kiketa. Saita. 78, 9, 80. Tinta order. Lordship may take up 2447. Didn't go into the facts, my lord. I'll just come to the law. Facts will take care of themselves. The question here is that there also, your lordship,
Section 8.3 under challenge, 8.3.
yes, that they also, your lordship asked about the review. That court has reviewed. So will it be, here, my lord, my reply will be, your lordship need not be part of by the review petition of the state and the leverages given by the division bench there. That may not be the only leverage to be given. Because that was in a closed circuit, my lord. Many people were not there because in the original petition, they being not there, they could not implicate themselves in a review petition. Therefore, notwithstanding the review, my lord, forget about that review petition. Notwithstanding the review, the consequence of the repealed act of 2011 and any act done in respect of that act were even otherwise preserved by section 6 of the general clauses. Lordship will, I'll press upon your lordship to take it that way. Now, General Clauses Act 6 provision is say,
Yes.
effect of repeal. Section 6.
Yes.
Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force or existing at that time, affect the previous operation of any enactment so repealed, or anything duly done or suffered, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under the enactment so repealed, affect penalty, forfeiture, punishment incurred in respect of any offense committed against the enactment so repealed, or affect any investigation, legal proceeding, or remedy in respect of such right, privilege, obligation, liability, penalty, forfeiture, or punishment. Now, there are two groups here. Pursuant to the 2011 Act, till it was set aside, some people were provincialized. Some people were being provincialized, are being provincialized. I will
That
refer.
is the, Mr. Bobra, that is the reason we are time and again asking this question.
Yes, my lord, I am trying to
The
reply.
persons who are going to be provincialized.
Yes,
Does it confer a right? If it does, section 6 will come in the way of 116/2006.
yes.
That's the question we are trying.
My
to
lord, lordship may kindly have a look.
pose.
Are being provincialized, section 2H of the 2011 Act. This is investigation, I'll come. 2H. This your lordship will get a নতুন এখন না? কোনখন আছে?
2011
ইয়াত নাই। আছে? থাকিব। Yes. Assam Venture 2011 Act, there your lordship will find page 2H.
Who are the people who would be provincialized?
Yes, 2H says employees means and includes all serving employees, both teaching and non-teaching of venture educational institutions who have been appointed by concerned venture institutional institution before first day of January 2011 and whose services are being or would be provincialized under it. Here we are.
So that's the most crucial provision.
Yes. Here, my lord, actually the question is, are being provincialized or would be provincialized, would have to be read with General Clauses Act. Just now I have read Section 6, this language. Would affect, repeal shall not affect any investigation, legal proceeding or remedy in respect of any rights, such privileges, etc., their liability acquired or incurred. Now I will take the case of, it says investigation. Take the case of the Prevention of Corruption Act. There were at the time when Section 5.1 was amended, no more, initially it was 5.1, beyond reasonable, beyond known source of property and all. That was subsequently became 13A and B. Then again came 2008. There was again amendment, 2018, new amendment, 13A and B came. Now, by the time the latest amendment came, under the old provision, investigation was on, those were saved. The job of filing a charge sheet was on under the old provision, and then trial held under the old provision. Then the question of acquittal or conviction. That is the ultimate thing. Provincialization is the ultimate thing. The process is on. That is saved. Am I clear to you, Lordship?
Yes, sir.
So that is where, my lord, one case is there, this Manipur case. Lordship may kindly have a look at the Manipur case. It is there. This case was of 2022. This is Bhimalanju. One Assam Act was declared unconstitutional in Bhimalanju case. Then this went to Supreme Court, 2018, volume 14. Then, my lord, the relevant paragraphs will be paragraph 15. Paragraph 15.
Yes.
After the judgment of this court in Bhimalanju Roy, Parliamentary Secretary resigned and the repealing Act 2018 was notified on 4/4/18. Contention of appellants is that PIL number so-and-so became infructuous after so-and-so Act was repealed, and therefore High Court committed an error in declaring Act as unconstitutional. In so-and-so, it was stated, Chief Justice, I take the effect of repealing a statute to obliterate it as completely from the records of Parliament as if it had never been passed. And it must be considered as a law that never existed except for the purpose of those actions which were commenced, prosecuted, and concluded whilst it was an existing law. There I am. There I am. And then it says, in the case of state of UP, it says, paragraph 22, 15, in paragraph 15, it is quoted, it is settled legal position that whenever an act is repealed, it must be considered as if it had never existed. The object of repeal is to obliterate the act from the statutory books except for certain purposes as provided under Section 6 of the General Clauses Act. Repeal is not a matter of mere form, but is of substance. Therefore, in repeal, the earlier provisions stand obliterated, abrogated, wiped out wholly. The aforesaid judgment have no room for doubt that after enactment of the repealing Act 2018, the 2012 Act did not survive and the High Court ought not to have considered the constitutional validity. To that extent, the High Court committed an error in declaring a non-existent law as unconstitutional. It is beyond question that this court of Bhimalanju, while dealing with the Assam Act, which is ad verbatim to the 12 Act, held that the Assam Act was vitiated due to lack of legislative competence. However, 2012 Act was not dealt with by these courts, and the same continued to be valid till it was repealed. Indeed, 2012 Act was not declared unconstitutional by any court before the High Court delivered the impugned judgment. And therefore, it was well within the competence of the Manipur legislature to repeal 2012 Act. High Court has committed an error upholding that Manipur legislature did not have the competence to enact. Repealing Act could not have been made. Law passed by legislature is good law till it is deemed to be unconstitutional by a competent, declared to be unconstitutional by a competent court, or till it is repealed. There is no error committed by Manipur legislature in repealing 2012 Act in light of judgment of Bimalans. Now 17. The crucial point that arises next for our consideration is the validity of the saving clause in the repealing act. It was submitted by appellants that the act done or decision taken during currency of the repealing act required to be saved to avoid confusion. So and so submitted that decisions made by persons appointed under 12 Act can be saved by virtue of A, the de facto doctrine, B, the express saving provision of the repealing act, C, section 6 of the general clauses act. And then paragraph 21. Elaborating this point. He quoted Goloknath, doctrine of prospective overruling can be invoked only in matters arising up, can be applied only by highest court of the country, Supreme Court, as it is. The scope of the retroactive operation of the law declared by the Supreme Court, superseding its earlier decision, is left to its discretion to be molded in accordance with justice of the cause and matter before it. So meaning thereby that in this group, before the repeal of 2011 Act, the district committees scrutinized our qualifications and all, recommended it to the higher education, and higher education department recommended it to the finance department at that stage. We acted for it. Now it is a transaction. It is a transaction. And transaction of decision. And there are other decisions. my
So
lord.
as you conclude for this particular matter, we want to leave you with a little thought. That question will definitely pose very heavily on the State Council. An act of the legislature can either be struck down by the court, competent court, or repealed by the legislature. These are the only two known means of obliterating the act. There is no third way.
Yes.
In this case, which of the two has happened? Insofar as 2011 Act is concerned, can you please tell us? Has it been struck down? If it has been struck down, then why is it mentioned in section 24 that it has been repealed?
No,
If it has been repealed, then where is the question of striking down? Both can't happen.
no, because all those who have been provincialized in between,
No, kindly see the provision, section 24,
yes, repeal and setting.
2017 Act.
Yeah. Yes. 24 of this 2017 Act.
17. Please have a look at it.
Yes, yes, I have seen it. Lordship was referring to this also that day. Last section. No, move on today.
Both the things can't happen. It can't be that an act has been struck down by the court, then the legislature repeals.
No,
That can't happen.
If the province or preachers already provincialized
No, we'll come to that later.
got away,
That is later. What has happened in this case? Has the court struck down or the legislature has repealed?
2011, my lord, it was declared to be invalid and it was.
Please read
Yes,
24.
Then the sitting. Yes, I understand.
We should have a bearing at some stage. We don't want to disclose.
We
that.
might.
But therefore the question is,
24, my lord, here it says 2011 as amended by so-and-so, amended by 2012, which have been struck down by the Honorable Guwahati High Court by order so-and-so, and all rules, orders, notification issued thereunder shall stand repeal. However, this is the minor rider given by the legislature.
shall stand.
However,
repealed.
all teachers whose services were provincialized prior to so-and-so shall continue and their cases shall be reviewed as per the eligibility norms set for provincialization under this act. Now, it is not for me, it is for this category of petitioners to argue, how can you now review us? That is one thing. That is not my brief. That is not my brief. My brief is, along with those provincialized, we are the ones whose cases were recommended exactly by this date.
In the
Now,
pipeline, in the pipeline.
In the pipeline, recommended at this table, at this stage, and then at the final stage.
So we are saved by clause 6 of General
Yes.
Clauses Act.
Yes. Like this Prevention of Corruption Act. Investigation goes on, earlier provision.
Therefore, 24 prima facie
Yes,
appears
yes.
to be.
Therefore, I have also submitted before your lordship that the word reviewed, it was not court review. It will be again reviewed by them. They at the same time say that those who are provincialized already, you are benefited already, go and get state time scale, public servant. Then you say their cases will again be considered what is judicial.
Yes.
So in this case, like Manipur case,
Case 24, review under which act?
yes,
Review under, what are the parameters of review under this?
it
review?
cannot be reviewed under the same act, earlier act. After that particular date, that is the date of judgment.
Under this act,
Yes.
therefore, those are also brought into under this act,
Yes.
not 2011 act.
11 act. It is act. So once you give the benefit, unconditional benefit, you go, you are provincialized, go, you are a public servant, all service conditions applicable to a public servant will apply to you, then there is no question of you having a review power again. And then deprovincialize. Review means what? Deprovincialize them? No. Similarly, those whose cases were recommended. Yeah, I have shown the Manipur case. When I come and fit in the group, my lord, there are so many cases. I'll try to place some of them. I conclude there, Masobla.
Yes.
Am I written this thing, my lord, written argument? When your lordship reserved the judgment, my lord, within 2-3 days, everybody can,
All right.
in a lengthy case like this, much obliged. Obliged for patient here.
Gather all
Relax.
judgments properly, huh? That's when filed. Things have to be filed. You have to maintain a file. It has to be prepared finally into a paper book with index. Okay. So keep gathering this as it comes. All right, now. Which are the cases? Group. Carried up to group 13, is it?
49. In this case, senior counsel, my lord, BC Das will argue. So fix this matter on Monday, man. He will lead this case.
Yes, my lord. Particular this group D.
We have engaged BC Das, sir. He will come on Monday, my lord. Today he is not giving that.
May I please, Lordship? My lord, this group 15, we are appearing in this group 15, 64, 69, my lord, 66 to 69. These are tagged with the group 13 matters, my lord. Similar matters have been, my lord. We are also challenging section 3.1.11 of the 2017 Act, my lord.
So who's there in item 65? Please follow out item 65.
Item 65.
One minute, 1 minute.
Group 14, my lord.
Yes.
Yes.
Other points are covered, so I'm not only regarding my challenge to my lord. Section 317 and 424, my lord. Now, I have given a written submission, my lord.
Is there anything you want to submit?
Yes, my lord. Only on regarding that, this is the only case challenging, my lord. Section 3, Rule 3, Sub-Rule 1, Roman 7, and Rule 4, Sub-Rule 2. And what happened in this case, my lord? Our institution has been provincialized. Admittedly, we don't meet the qualification requirement of there. Therefore, our entitlement for the timing is only tutor, my lord. So those who are not eligible, they are eligible for continuing as tutor for 5 years. If they get the qualification in that period of time, they'll be recruited as teacher. Otherwise, they'll continue as tutor, my lord. The posts are personal posts, my lord. Under these two rules, my lord, a further qualification has been added
1 minute.
that for being eligible for provincialization,
So why you are challenging this provision?
the object of the act is that it has to, it's a one-time exercise. It has to provincialize all the venture institution and the teachers, my lord. And therefore, the act says that those will be qualified, they'll also continue. Those who are not qualified, they'll also continue. The further qualification has been added that for being eligible to continue as tutor also, my lord, there should be 10 enrollments of students in the previous year, my lord. These 3 teachers, my lord, they don't fulfill that, my lord. Only in 2016.
How many petitioners in your
3
case?
petitioners, my lord. They are teaching, my lord, economics, history, and Hindi.
But they are working as tutors.
They are not now provincial because that benchmark, they are not that enrollment part, my lord. But their entitlement, their claim is for tutor only because they don't meet the eligibility criteria.
Then
So section 314 says for the core subject, there should be at least 10 enrollment in the previous year. Section 424 says for the classical teachers, there should be 10 enrollment in last 3 years.
Yeah.
So my submission is, my lord, this is the factual part, my lord, because we have accepted that we are not eligible, we'll continue as tutor, my lord. But that is also not possible because of this enrollment clause in that particular 2016 only. Fortunately and unfortunately, who could not cover this in 2016, they are not eligible for. But my submission is that, my lord, when the act envisages that both qualified and non-qualified should continue, adding a further qualification is arbitrary, my lord. We are not qualified, we'll continue as a teacher at base, my lord. So adding this enrollment is, my lord, that is not a prescription. If your lordship sees, my lord, 2011 Act was annulled by the repealed by the government on the institution of government on three grounds. Firstly, it does not cover the reservation law. Second thing, my lord, that the 2011 does not meet the requirement of 3 central legislation, and 1 is financial burden, my lord. Now, only these things are corrected, my lord, then enrollment part would not have come. Enrollment is not the prescription of any act, my lord. My right for being provincialized cannot be a matter of luck, my lord. I have given 15 years of service. Now I want to continue as teacher. That cannot be a matter of luck. That what was the enrollment in the previous year, my lord. So my entitlement for being provincialized does not depend on as a matter of luck. And the teachers, my lord, they cannot be held responsible for enrollment, my lord. Some year there may be more. Now petitioner number 1 here, he was having enrollment much more than 15 and 17 last 2 years. But 2016 he did not have that on economics. And the result is this, my lord, due to this provision, from this institution, economics, history, and Hindi will never be taught, my lord. These subjects are eradicated from this institution, my lord. That is also, my lord, not in the interest of anybody.
Commissioners are not working at the moment.
They are not. After this, my lord, going to school doesn't matter, my lord.
No, that is understandable, but the point is, what is the order you are seeking from the court in your writ petition?
My lord, we're saying that this clause, which gives a prescription of 10 enrollment in the previous year only, this is arbitrary, my lord. This is opposed to the object sought to be achieved by the act, my lord.
But that's not the ground to strike down a provision.
My lord, that is true, my lord, but anything which is arbitrary and unreasonable, my lord,
That's also
that
not
is-
a ground to strike down a statute.
is arbitrary, my lord, is in violation of Article 14, my lord.
Arbitrary, every statute is discretion of the legislature.
Fine.
You can't test arbitrariness like a government administrative action. You have to tell us on what ground the court can interfere.
My lord.
Maybe it's unfortunate, maybe it's a harsh consequence. But then if the statute does not permit, the court cannot likely interfere with the
My lord, that is true, my lord.
statutory provision.
But if that clause is there, I have no remedy, my lord.
No, maybe, but that's the idea behind the clause.
No, that's why I can always challenge, my lord, if it is on the face of it, arbitrary
You
logic
can
comes to know.
always challenge, but you have to tell us the ground on which you are challenging. The grounds you are urging, the judgment can be delivered right now dismissing the petition.
My lord.
These are not grounds to strike down a statute. Then why are you challenging? If you're conceding it, then why are you challenging?
My lord,
Then you have to argue a ground which makes us think and explore for what relief can be granted.
my lord.
Or else, if you're arguing about something which is contrary to settled law, then we'll dismiss your petition. What else can be done?
I have understood, my lord. If lordship consider that these clauses are reasonable clause, my lord, then it will be there, my lord.
The unreasonable clause sections in the statute cannot be struck down by the court. These are very unreasonable,
My lord.
very arbitrary. It cannot be interfered. That's the law. Now what do you have to say? Arbitrary, you're not challenging an order of the secretary of the department.
My lord.
You're challenging a statute framed by the parliament, by the state legislature. You are advancing arguments which are meant for challenging state's action on the administrative side, executive action. That's surprising. Your petition will be dismissed because no case has been made out. Either you make out a case or else why are you pressing it? It's a meaningless exercise. In those
no,
grounds
this-
you are
this is-
arguing the statute.
My lord, no, this is the specific, what is peculiar to this fact, my lord, I have submitted. Other grounds that why 2011 people are continuing the same batch platform, they are already, my lord. I'm not pressing because this is being argued in length, my lord. That's why I'm not going to all these things, my lord. Those grounds are already there. Because I was entitled for under 2011 Act. Some have been provincialized. So I'm not repeating that, my lord. Your lordship has heard the matter in length,
No, don't repeat that.
my lord.
But this is no ground. The ground that you are
Well-
urging is no ground.
My lord, my only submission would be, my lord, is something is arbitrary, that be unconstitutional, and therefore that would be, my lord,
Anything arbitrary is unconstitutional.
article
Anything
violation
is
of
law.
Article 14, my lord. Anything arbitrary and unreasonable is 14, and anything unconstitutional has to go.
Want to consider what relief can be granted to your client. You're not giving us an opportunity. You're
My
not
lord, that,
assisting the court by saying something which is of some relevance.
my lord.
What to do,
My lord, that
right?
I think factual thing is very small that I've submitted before.
Principle of law you are espousing.
No, if I'm challenging what your lordship is,
Okay.
my lord.
Yes. You want to say something on group 15?
15, my lord.
You are appearing for all the petitioners.
Yes, my lord. We are challenging section 3(1)(11) of the 2017 Act, my lord. Which are also challenged in group 13, my lord. So our matter may be fixed in group 13, my lord.
Same as group 13.
Same as group 13.
Your name, please?
M. Agarwala, my lord. My lord. My lord, the only mistake why my this case has been kept in group 15 because I have committed one mistake, my lord. Instead of 3(1)(11), I have mentioned it as 3(11). That's so I may be allowed to correct it this time, my lord.
You want to correct it by overwriting.
As your lordship directs me,
No,
either
it can't be done.
I will file separate application for that,
File amendment application.
my lord.
Yes.
My lord.
Yes, who's appearing in group 16? Yes, 17, 18, 19.
Group 18, 73, 74, 75.
Yes.
Lordship, my group is 18. My item number is 78. Lordship,
70, huh?
75, Lordship, 75. 75, Lordship, item number.
Yes. You're challenging section 3, subsection 2.
Challenging section 3U, Lordship. Lordship, just facts, Lordship, my case is somewhat different from the other ghosts because, Lordship, after 3 rounds of verification process, Lordship, our services have been provincialized in the year 2021. Now, Lordship, the director has passed an interim order topping our salary, saying that section 3U
You get it segregated from the list. We are not going to go into the facts.
Lots, yes.
In none of the cases, we are going to go into the facts.
Lots, we have already, we have already gone through a single judge, lots, 2 orders. This petition has been disposed of by a common order.
Mr. Das, you want it to be listed separately or within this?
No, lots, I also have challenged the virus, lots, section 3, lots,
We are not going into the facts.
lots,
Facts will not be discussed in any judgment.
lots,
Just project the cumulative,
lots.
what are the broad areas?
Brought it.
Provided Mr. Majumdar gives us a note on that.
Lots.
You have given us the note on the. You have given- All right, we'll do some, make some, you understood what we are asking for. Yeah, on the basis of grievances, how they can be clubbed together as homogeneous groups. That's the point.
The application of the new pension scheme for all.
We are not, these will be discarded, will be taken out from this group. Mr. Das, if your
Lots, may kindly see paragraph.
grievance is this,
Lots,
your petition will suffer if you remain in the group.
lots, may kindly,
All right,
for one space 21, lots, paragraph 17, lots, my ground, lots.
but you are causing damage to your client.
Lots, that.
Just because you want to wash off your hands of the brief. That's what we get the feeling. Your grievance is completely factual.
That is only pertaining to stoppage of salary that has been taken care by the learned single judge. It has been remanded back to the government by making some observations, lordship. Now, this is with regard to lordship, our permanent absorption, lordship, because we are still working. We are still working, but salary has been stopped from July 2021 lordship. Only for that particular section 3U, wherein it is says that the concurrence of the subject should be from each of the Yes.
Please go ahead and argue. We will only say which provisions are valid, which are not.
Lordship. Lordship,
Nothing more than that in
Lordship.
this batch.
Lordship, I have explained page 21, paragraph 17, Lordship. That section
We
3.
will not say pay anybody's salary. We will not say don't pay his
Lordship.
salary.
Lordship. That has
The
been.
only thing that the court will opine in this
Lordship.
batch of writ petitions is on the question of challenge to the virus of the act
Lordship.
and the various provisions. If we find it is all valid,
Lordship.
we'll say so. If we find it is not valid, we'll say so. If we find it is partly valid, partly invalid, we'll say so by giving our reasons.
Lordship.
Just to make the catalog of facts complete, we will broadly categorize the grievances of the petitioners into homogeneous groups
Lordship.
so that anybody reading the judgment knows what is the nature of grievance and why the petitioners have approached this court. That's all.
Lordship.
Who is being considered, who is not,
Lordship.
which date, whose approval came. Nothing will be gone into the judgment.
Lordship, section 3U, Lordship, I am just praying for laying down that portion in respect of each of the subjects, that subjects be considered along in the respective institution. Only that much, because the process started long back. Similarly situated, our colleagues, Lordship, their subjects were taught, and we also taught some other subjects. Their services were provincialized because their concurrence came before 1/1/2006. Our subject concurrence came after 1/1/2006. And Lordship, my ground, Lordship, is with regard to this has created an unreasonable classification. I have explained in page 21, paragraph 17, Lordship. Unreasonable classification amongst the equal success other teachers whose subjects were initially included in their schools and having treated them from the date of school concurrence, while on the other hand treating the subjects taught by the petitioners as subject concurrence received after the school concurrence on 1/1/2006. Although they were also working from the earlier point of time, is validity for Article 14 and 16 laws. Because Lordship, we also taught the same subject. Our process started much earlier, Lordship, and we are working since 2009, 2010. Sorry, Lordship, 1993, 1999. When the subject concurrence came, Lordship, it was after 1/1/2006, but the process started much earlier, Lordship. That is our grievance. So, Lordship, our prayer is to, Lordship, please, Lordship, consider
lay down that particular portion, Lordship. That subjects be considered along in the respective institutions.
Actually, you mean read down?
Lay down,
Yeah,
Lordship, lay
Lay
down.
down.
Lay down.
What is lay down? We have not, what is the meaning of lay down?
That portion can be, Lordship, that particular portion, Lordship, section 3U.
Are you saying read down?
Lay down, Lordship.
Huh?
Lay down.
Lay down. We have not heard it. Please argue on that. What is the meaning of lay down?
To amend this particular section.
Huh?
To amend, Lordship, this particular portion.
Amend.
Lordship.
All right, we will prepare a legislative assembly here and amend.
Or Lordship, I have also challenged the virus, Lordship, section 3U. Lordship, may I kindly come to section 3U once, Lordship.
Mr. Majumdar,
Lordship.
we have to carry out an exercise to amend the act. On Monday, please tell us how it can be done here. We have to make a makeshift assembly and then carry out amendment.
Lordship, I have also used the word challenging the virus, Lordship. Challenging the virus and alternatively to lay down, Lordship.
You
Two words
want
are-
amendment also?
No, I have challenged the virus of section 3U. As also I have written, Lordship, to lay down that particular portion. That minimum enrollment and
Mr. Das, it's not called lay down, it's called read down.
read down.
After twice mentioning it, you are still not understanding.
Lordship.
What you are saying doesn't make any sense. The court cannot lay down
Yes,
part of the statute.
yes. Well,
Have
that,
that much of
yes, Lordship. That meaning
basic
says put something
understanding,
down.
at
Lordship.
least. You are arguing a matter in the High Court.
Lordship.
Again and
Wait,
again, you
wait.
are saying lay down, lay down. All right, all right.
Lordship, I can also make a short submission, a short written argument, Lordship, to paste it.
But don't write lay down there.
Lordship. And Lordship, may I
And
place
also
the,
don't ask the court to amend the statute.
Lordship, may I place
Otherwise
the
not
Learned
possible.
Singular's order, Lordship?
Huh?
May I place the Learned Singular's order with, because there are some observations, the earlier petition.
You keep it, you will need it later also. Once we have said we are only looking into constitutional validity, why are you giving all these things? Single judge's order, directing that your case should be considered. What relevance it has with this matter? Amazing, you are not understanding
regard
basic
to-
communication from the court.
Only with regard to stoppage of salary, Lordship, that part.
So how does it matter?
It doesn't matter, Lordship. In this particular case, Lordship, I have challenged the headers of section 3.
Nothing. You are completely not appreciating what the court is saying. All right, anything else on this?
So also I make a written submission. Also. Problem.
Group 19, item 76.
Lordship, so far as item 74 is concerned, your Lordship,
Yes.
section 3(2) has been put to challenge, your Lordship, virus of the particular provision.
What is 3(2)?
3(2), your Lordship, Learned Senior Council has already, your Lordship, argued on that, your Lordship, in item 98.
What is 3(2) about?
Lordship, it is, your Lordship, in respect of degree college and higher secondary schools and junior colleges, your Lordship. The eligibility criteria specified in subsection 1 above regarding date of recognition, affiliation or concurrence, minimum enrollment and performance would mean in respect of each of the subjects which or without major as the case may be, and the services of the teachers appointed or engaged in connection with this is such subject and subject shall be considered for provincialization under the provision of this act. This provision, your Lordship, has been put to challenge in this petition also. And Learned Senior Council, your Lordship, has already extensively argued on this, your Lordship. I am adopting that argument, your Lordship. So far as 3(2) is concerned.
Yes.
That will cover our case also. Obliged.
73,
Lordship, I'm appearing in item number 73, Lordship.
Yes.
Lordship, I am also in the similar footing, Lordship, challenge to section 3, clause 2 of the act, Lordship.
All right.
Lordship, I am also adopting the argument of made by Learned Senior Council, Lordship.
All right. Do you want to add anything?
Lordship, No, Lordship.
You are Mr. PJ Datta.
H. Mojumdar, Lordship. I'm appearing on behalf of Mr. BP Bora, Lordship. He's out of station. Lordship, only one point, Lordship, I would like to add, Lordship, regarding repugnancy, Lordship. Lordship, my senior counsel has already raised, Lordship, I have made a ground, Lordship.
Don't repeat, you can add anything you want.
Yes, Lordship. Deeply obliged, Lordship. Please. Repugnancy in respect of repugnancy, Lordship.
You want to make some submission?
No, Lordship, it's okay. No, Lordship, I humbly submit, Lordship. The same submissions made by senior
You want
counsel.
to adopt?
Yes, Lordship, I want to adopt. Deeply obliged, Lordship.
Item group 19, item 70.
It to same it.
Yes.
This one also, Lordship, 8-3 ought to have been challenged, Lordship, but due to typographical error, it has come up as 8-2, Lordship. So
No, see, this overwriting by pen, those days are gone, long back.
I know, Lordship, but if I'm allowed, Lordship, I may.
File an application for
Lordship,
amendment. It
I'll
will be
file that.
hard, the other side will file objection. Then if the court allows, then you will have to file new petition. Other side will have to file affidavit if they want to file. Then the matter will be listed for hearing. Then your case will be hard.
It'll take a long
This is
time.
unfortunately the position today. Of course, in some places, some courts may allow handwritten, but we think it is not legal. It cannot be allowed.
If I may be allowed to prefer an application, Lordship,
Who is stopping you? You can please file it.
Lordship. Yes, these are all principals, Lordship, as appointed as future tutors.
Then you have to get this out of this list.
And they are tutors, Lordship, but appointed as,
You want this matter to be listed separately.
no, Lordship, just allowing to file an application.
Reserve a judgment and dispose of all cases. After that, you file your application. Why is there so much of confusion? You want to file an application for amendment, but you don't want to segregate it. We will reserve the judgment next Monday and finish it off. Thereafter, you file your application wherever you want to file. All right, next matter, please. Yes. Item group 21.
Group 21. 78, 79, 80.
Senior Mr. A.C. Barbara has already argued in this matter.
Item 22. 81.
What item group?
Group
22?
22.
May please, your lordship. In this matter, Mr. A.R. Bhuya will argue, my lord.
Mr.
A.R. Bhuya, my lord. Kindly, my lord, this matter will be taken up on Monday, my
We
lord.
will only post it on Monday for if half an hour for Mr. B.C. Das and Mr. K.N. Chaudhary has asked for 15
Then,
minutes.
my lord, after some
Apart from that,
then
it will be
after
the
some,
state's response.
after some time, my lord.
Sorry, it cannot be done. If he comes before we rise, we'll hear him.
My lord, after
Cannot
some
be
time,
done.
my lord.
Monday will not allow anybody else.
After some time, my lord.
Before we
My lord,
rise,
my lord,
or
before,
you want us to wait for him?
no. Before rising, my lord. Item number 82 and 83 also, my lord.
Section 316 and my lord 424. My lord, by section 316, my lord.
Four to four.
424 and my lord 316. Now, my lord, in terms of 316, my lord, earlier another 2011 Act, well, the criteria was that, my lord, in the last, my lord, since 2006, in all the examinations, in any of the three examinations, the school must have candidates, so 30% of the candidates of the school must have passed the examination. Now, under the 2017 rules, what has been done is that in the last 3 consecutive years, 30% has to pass. So that is the change that has taken place. Now, similarly situated teachers who were provincialized under the earlier Act, they went kept through under the earlier Act. Our cases were under process when this Act was repealed, my lord. So, my lord, therefore, there's a distinction, my lord, arbitrary distinction being created, my lord, two homogeneous classes of people who were earlier provincialized, my lord, and who are left.
Fundamentally, if the court holds
My lord.
that those schools and those teachers
My lord.
who had acquired some semblance of right under the previous
My
Act
lord.
would stand exempted,
My
or
lord.
the Act is, the 3(1) proviso is read down.
My lord.
You get the benefit, otherwise there is nothing. for
Yes,
you to
well,
argue.
therefore, I would like to, my lord, just place 131 again, once again, my lord. Well, what has happened, perhaps one question Lordship is asking, who was the persons who would be provincialized? Now, if a Lordship looks at, my lord, 3, my lord, section 3, my lord, Lordship will find, my lord, there are 2 categories, in fact, within
Section
that.
3 of the,
My lord, the 2011 Act, my lord. Sorry, rather, section 4, my lord, 4. That is the deeming provision, my lord.
yes,
Now, Lordship will find, my lord, it is these deeming provisions, my lord. Employees to be government service, my lord. Yeah, Lordship has, my lord, already, my lord, read it, my lord, number of occasions, my lord. Well, but Lordship will see, my lord, there are 2 provisos here. The first says the services of all the employees of eligible institutions, education institution under section 3 shall be deemed to have been provincialized on the date of coming into force of this Act, and they shall become employees of the state government with effect from that date, provided the institutions have completed 7 years of imparting education from the date of affiliation, recognition, concurrence, and or permission, as the case may be, on the date of coming into force of this Act. So this is one category, my lord. Second proviso, Lordship will find, my lord. Provided that the services of employees of the venture education institution shall be eligible for provincialization under section 3, who have not completed 7 years for imparting education from the date of their affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into the force of the Act, shall be provincialized as and when the concerned education institution completes 7 years of imparting education from the date of affiliation, recognition, concurrence, and so on. So, my lord, the 2 categories, my lord, one is would-be. The would-be is category who are not completed 7 years, my lord. So far those 7 years are concerned, my lord, who have completed 7 years, my lord, in my humble submission, my lord, they are deemed to be provincialized with effect from the coming of that, from that date when the Act came into force, my lord, 2011 Act. So these persons have a semblance of right, my lord. And, my lord, on that, my lord, I'd like to place one judgment, my lord. It's of, my lord, where, my lord, the deeming provisions have been, my lord, discussed, my lord. Which? My lord, it's, my lord, it's reported, my lord, in 1980, my lord, Supreme Court AR 1988, Supreme Court 1468, my lord. My lord, I would read, my lord, paragraph 11.
are you referring to 1983 SCC 358?
My lord, SCC, my lord, of course, it's reported, my lord, in SCC also, my lord, in the, my lord, in the AR also, my lord. That's the judgment, my lord.
What is the name of the?
My lord, it's consolidated copy.
Yes.
Yeah, that's the judgment. Well, I'll read paragraph 11, my lord.
But then we have got the SCC.
My lord, same paragraph, my lord. Same paragraph. Paragraph, that is also paragraph 11. I've checked it out, my lord.
Para 11.
11, my lord. it is not possible to accept the aforesaid contentions for the reason which we shall presently indicate. It is true that the word deemed has been used in section 5.3 of the same, but the same word has been used not merely in section 5.1, but also in the other sections 3 and 4 of chapter 2 of the Central Sales Tax Act, which has been heading formulations of principles for determining when a sale or purchase of a goods takes place in the course of interstate trade or commerce, or outside the state, or in the course of export or import. The heading of chapter 2 on the face of it suggests that it was done under sections 3, 4, and 5, including subsections 3, in formulation of principles. Secondly, the word deemed is used a great deal in modern legislation in different senses. And it is not a deeming provision that a deeming provision is made every time for the purpose of creating a fiction. A deeming provision might be made to include what is obvious or what is uncertain, or to impose for the purpose of a statute an artificial construction of a word or phrase that would not otherwise prevail. But in each case, it should be a question as to with what object the legislature had made the deeming provisions. The word deem is used greatly in the modern legislation. Sometimes it's used to impose for the purpose of the statute an artificial construction or the word or phrase that would not otherwise prevail. Sometimes it is used to put beyond doubt a particular construction that might otherwise be uncertain. Sometimes it is used to give a comprehensive description that includes what is obvious and what is uncertain and what is in the ordinary sense impossible. After making these observations, the learned lord went to hold on that it was the last of the three ways indicated in the observation that the deeming provision was made under section 58(2) of the Finance Act 1940, which came for interpretation for the House of Lords. Similarly, in the words and phrases permanent edition so-and-so, it is explained that the word deemed is also used to mean regarded as being. It is equivalent to be, shall be taken to be. At page 85, in our view, section 3, subsection 3 of section 5, the word used deemed and says that the penultimate sale shall also be deemed to be in the course of export. What is intended to be conveyed is that the penultimate sale shall also be regarded as being in the course of such export. Well, in this case, my lord, the distinction between deemed provision and has been made by keeping some people out of the provision, those who have not completed 7 years. And that is why perhaps that some people would be provincialized and some people are provincialized. That's the in section 2, employees, section 2H. Employees means it includes all serving employees, both teaching and non-teaching of venture educational institutions who have been appointed by the concerned venture educational institution before the first day of January 2011, and whose services are being or would be provincialized under the Act. So would be provincialized under the Act are those people who have not completed 7 years and who will be provincialized later on. So my humble submission is, these petitioners, their rights had already been crystallized. In the sense, that as per the provisions of the Act, they had completed 7 years of their service, and therefore they were deemed to be provincialized from the date of coming into force of the Act in 2011 itself. So they stand similarly situated as those who have been given the I would call it giving you the benefits of provincialization. One is the word provincialization has been attached, and I would say these people who have got have got the benefits of provincialization in the sense that they have been getting the salaries, etc., etc. But these persons, though provincialized, were left out of the benefit because in the meanwhile, the state took a decision that the Act is it's not constitutional. The Act has got lacuna, so therefore they wanted to review the Act or have a new Act together, brought together, and that on that concession it was set aside by the Honorable Court. So that was stuck by the Honorable Court on that ground, and the exercise which was to be taken subsequently, was only supposed to cater to those lacuna which were there, not to bring in a new Act altogether. What has done been done here, they have brought in a new Act altogether, and which is further discriminatory, because earlier also their stand was that this Act is discriminatory.
So, Mr. Datta, can you tell us, among the petitioners in the first round, is there any aggrieved party here in the second round?
My lord, at least
Can it be said that they labored very hard to get an Act brought in which cuts them to size? Can it be said that? Is that the situation?
That of course, my lord.
People have worked hard to shoot in their foot, something like that. The petitioners who said this was bad,
My lord.
landed up in a situation it is worse.
Yes.
Is that the position here? And the government
That-
grabbed this opportunity with both hands.
That has been argued, my lord, when I heard they said the remedy is worse than the cure is worse than the disease, my lord. Someone
That
argued
is-
that, my lord.
that is
I heard that
all
sentence.
right, but these people have worked very hard to ensure that a law comes which completely
Takes away
eliminates.
everything that they aspired for. আগৰখন গুচাই ল'লে, এইখন মৰিলে। 24 Yes. Irregular. 24 effective করলে আনা তো রেগুলার
Yes. Well, my submission to be that these people had their right crystallized at that point of time. Therefore, my lord, they were at par with those who were getting the benefits of provincialization. And now to discriminate, my lord, them is with this my lord, discrimination is my lord, without any reasonable basis, my lord. This unreasonable. My lord.
What is the discrimination? Now their regulation under 24 is deemed to be withdrawn. They are only allowed to continue till their qualifications are considered in terms of the new act.
Well, that has still not been done, is it, my lord? That
May
has
not be done.
But then, my lord,
But fact remains,
My
that both you and them are in the same.
no, my lord, what might happen here, my lord, is that this reconsideration, review, that would be perhaps, my lord, if someone has been put as a teacher or tutor, if they don't qualify in this 5 years or 7 years that has been given, then the things might take a different turn. That's another point. That's something different, my lord. And now, my lord, some is.
No, their cases are to be considered in terms of the present. act.
Exactly, my lord, exactly.
So there may be persons who are people like you whose services that you are creating.
No,
a
my lord,
group,
my
somebody
lord.
got provincial.
My lord.
That argument is not correct because they are not yet provincialized.
No, my lord,
In terms of
my lord, there is a distinction here, my lord. There is a distinction here, my lord. This act operates in different layers, my lord. One is provincialization of the, my lord, one is the criteria for the schools, and one is the criteria for the employees. Now, my lord, so for the criteria for the school is concerned, my lord, here what has been changed is the criteria for the school, not the employees as such. It's for the criteria for the school. Now, that criteria has not been changed. That criteria will not be considered while reviewing. What is said is that educational qualifications, etc., will be this section 24, your lordship reads. That section 24, my lord, I will just place it before once again before my lords. That section 24, it doesn't talk about, my lord, the change of our criteria, my lord, the criteria under which the schools were provincialized, my lord, that would be changed. It only says my lord, reviewed as per the eligibility norms set forth for the Provincialization Act. So, my lord, all the teachers whose services provincialized shall continue and such cases shall be reviewed as per the eligibility norms, my lord.
Or
So,
norms of.
norms set forth in the Provincialization Act. My lord. This
Which set?
eligibility norms my lord, would be basically, my lord, with regard to the qualification. Of course, it's not very clear, but it would be my lord, the qualification, my lord, because they have here, because they have put a clause that you have to pass, complete this educational qualification, have this educational qualification in this period of time. If someone doesn't get it, then there will be a question of reshuffling or review of their cases. So that is what it is intended, my lord. So therefore, this, my lord, it's actually, my lord, this is half-baked act. There are a lot of, my lord, inconsistencies here and there, my lord. The problem here is, my lord, it has been done, my lord, when it was, my lord, the state considered that this is a discriminatory act. They, my lord, and what they said that it is not as per certain central acts. Now, what they have done is, my lord, they have done something further. If it was only confined to removing those lacuna, then things would have been different, perhaps. Perhaps we have had no ground to challenge. They have not done that. They say that earlier act was discriminatory. Now they're again doing something which is discriminatory. So they have not remedied actually anything which they had done earlier. The vice which was there, it still continues. It may have changed some shapes and forms. Some sections here have, some sections have been modified, some have not, some have been even made worse. So, but then that discriminatory clause, now that is what I'm saying. Once the right is crystallized, suddenly to say that some people belong to a different category and the similar out of the homogeneous class and some we are of a different category, that is an artificial distinction they're trying to make. And Lordship will see what the criteria, that criteria that has been given, that 3 years, that 30% pass, 30% pass percentage. Well, how does it, that's again, a question of, how does it affect, that the competence of the teacher, It cannot be this, the pass percentage cannot be determinative of, the competence of the teacher. If one says that you are linking with the competence of the teacher, that cannot be, It can differ for various reasons. In my school, in 1 year, 100% student pass. In 1 year, there was 5%. So it cannot be said that the teacher is bad, therefore the performance of the school was bad all through. In the 1 year, it is 100%. I've given a chart. In 1 year, it was 5%. So therefore, the question that the students' results of the school, it may not be, it cannot be determinative of the competence of the teacher, if the competence is in question. That will be determined by educational qualifications. If you have the qualification, that's a different issue. If they make a distinction on the basis of qualification, perhaps then it's a reasonable classification. Now, but to say that this percentage of people have to pass, now, for the classical teachers, 10 students have to be there. Now, in a particular school, classical teachers, and this is very different kind of a situation here in Assam. We have different languages being taught in different places. There may be Arabic, there may be Assamese, there may be English. The language as a subject, but you are regularizing only one language teacher. So when you are regularizing one English teacher, either you are saying that the Assamese student should not study Assamese, or the Bodo medium student shouldn't study Bodo medium. The English medium student should study, if there is no teacher, should not study English. That cannot be the way the education system can work, because all these languages are important for us. No language is lesser. So
your answer would be that we have provincialized the school.
Yes.
We need qualified teacher. So if we do not get a English teacher or Arabic teacher, we'll recruit it since it comes into the
fine. Qualified, but then here the provincial, what is the object of the act? Object of the act is to provincialize and to stop further growth. Now, what you are creating is a fetter for because the school will now remain intact. You are not closing it down. So therefore, it's contrary to the object of the act again. It doesn't further the object of the act.
Qualifications required for the building and other things.
No, but then my lordship will see how when these institutions came in the earlier judgment, my lord, it has been referred. They were, my lord, when the state had failed to, my lord, work on its constitutional obligations, to discharge its constitutional obligation to make education, impart education. These are the people who came in, my lord. The literacy rate in 1951 was 17%. Now it has gone up, my lord, to 71% in 2011. So these are the people, my lord, who have been instrumental, my lord. I will not say, my lord, they have done something extraordinary, even if it's not so, my lord. They have brought down up the literacy rate. And these are the people where it is a duty of the state, my lord. Much before, my lord, the Right to Education Act came, my lord. It was these people, my lord, who entered into this institution, nurtured these institutions, my lord, taught the students, my lord. And, my lord, they have, my lord, come today, my lord, where they are.
So, Mr. Chaudhary, we were asking, after these 3-4 days of hearing, the petitioners in the first round of writ petition, whether they have really done a great disservice to themselves by shooting in their foot.
So, my lord, what my learned friend is saying is perhaps...
No, it's not in reference to what he's saying. Generally, after the...
Generally, of course, my lord, for a meager sum, they were giving service, and the...
As my learned brother has pointed out, I have also noticed Section 24 apparently takes away the provincialization of those who were already provincialized under the previous act, because it is subject to review. After review, people can be deprovincialized also.
No, my lord, in my humble submission, eventually what your lordships may say, Section 6 of the General Clauses Act, Section 6C, has been interpreted by Supreme Court in a manner. It says whether there is a savings or repealing clause is not an important. What is important is in the new act, repealing act, whether there is any intention discernible whereby with the benefit which was already given by the earlier act is sought to be taken away.
That's why we are saying 24 does it.
No, I'm coming to that, my lord. Now, in this case, no, lordship will not read section 24 alone. Now, section 4(1) of the 17 Act also, it also is a provision whereby deemed provincialization is envisaged. There is a rider, but with a little qualification that you need to have this and that qualification, so and so number of students has to be there. Therefore, there is no intention to take away the benefit which was given by the earlier act. I'll place those cases, my lord. I think, and my lord, please for a moment that earlier judgment, review judgment, para 19, this is neither here nor there. That cannot determine the fate of these batch of cases.
That you can conveniently say.
No,
but
what I'm saying, no. Even there is no impediment on your lordship's part also.
No. The point is something different, and we actually want you to take note.
No, we'll address. No, well,
Just a minute. See, there are some areas which has set us thinking. We are not getting the
right answers.
Right answers. So at least being one of the lead councils.
No, I'll do.
Mr. Borbora has also.
No, I think, my lord, Mr. Goswami has indicated to me that I was in a hurry for some reason. So I thought, well, giving my reply, I'll cover everything.
Lot of issues on the constitutional fictions.
Yes.
Which needs proper address.
Yes.
These, of course, facts, this and that, we are not concerned with that. You see, let me on behalf of the bench enumerate the few areas which are setting us thinking. Mr. Datta, please bear with us.
No.
Continue. You see, the fundamental grievance flows from 3(1) Roman 1 proviso.
Yes.
Which inserts a cutoff date of 1/1/2006.
In some cases.
In some cases. Now, the argument is obviously that this cutoff date is arbitrary and it has been inserted to eliminate a particular large section of the teachers who were waiting and were expectant. Now, if you want to microscopically, forensically go into those issues, then there are some adjuncts to these issues which will also have to be looked into. First, what are the observations in the first round of judgment? The section 24 tacitly says it is repealed by the assembly. Now, a statute can either be struck down by the court or repealed by the assembly. It can't be both.
Yes.
What has happened here actually?
What has happened here is because there was a concession by the state, therefore there was a judgment.
We'll come to it. Here, the section 24, the state says because it has been struck down, so we are repealing it. What meaning do you give it to it? If an act has been struck down, you look at the consequences from one particular angle. If it has been repealed, then you look at it.
Therefore, my lord, therefore the answer lies in whether 2017 Act is a validating law. That aspect will have to be gone into, my lord.
That aspect has not been argued.
Yes, that's my point. I have argued that. It's not a validating law, therefore XYZ. What is a validating law, my lord? If there is a basis of a judgment, and when that basis is taken away by a validating law, then it's a validating judgment. Then invariably a validating law will operate retrospectively.
That happens when, say, a court judge verdict is sought to be.
Yes, validating law. Basically to take away the basis of a judgment.
No, this is not a validating
law. No. Then if it is not a validating law, then what would be the implication?
So it is a new enactment.
It's a new
It's
enactment.
a new enactment.
Ah.
But this question is relevant to see what would be the operation of section 6 of the General
No,
Clauses Act.
yes, your lordship is absolutely correct. Some meaning has to be given to section 24.
Yes.
In trying to give meaning to section 24, will your lordship not go into section 6C of the General Clauses
That's
Act?
why we are saying if the court says you can't give any right, then section 6 will not come into play.
No, my lord, that's not the issue. Issue is, in spite of the court order intervening, there is a new law. So therefore, my lord, that court order will not have any relevance.
But the new law is crossed on the court order.
But true, but end of the day, there is a new law. Whatever may be the reason. At the same time, it is not a validating legislation. I could have appreciated,
It
my
is a
lord.
compulsive legislation. Let's take it that way. Legislature says we are helpless.
No, my lord,
But is that the
we are in a very tricky situation. I have tried to find out an answer. It's not very easy. Because we can visualize a situation, a law is struck down because it is violative of Part 3. Then legislation makes an attempt to take away the basis, then it's a validating law. A law is struck down, government of the day accepts it, comes up with a new law, not a validating legislation.
Absolutely. Court has no business saying anything.
Then
Either the law is bad, struck
this
down.
legislation is what? I think a new category has come up.
So what is that category? We are trying to
No, my
understand.
lord, to be honest, I am yet to come across.
No, because this is Mr. Chaudhary, we have to write out a judgment.
Yes.
All these are heavy constitutional principles.
And moreover, that para 19 of the judgment is creating more confusion to the whole.
Therefore, we are trying to understand at least.
Therefore, my humble submission would be that para 19 may not have any relevance. It has, in the facts of that case, some observations were made that it has to be kept at there.
No, a coordinate bench can't say a para doesn't have.
No, it's not. No, my lord. Then we can also say that 42,000 people in whose favor that observation was there, then another 32,000 whose cases were considered and recommended. So what is the difference? If that benefit was given to them, then following para 19, benefits should be given to the balance
Why don't you
32,000.
seek a review of that order and get further clarification?
Review? With all respect, my lord.
No, is it a feasible option? If not, why not?
We can think, but prima facie doesn't look like.
No,
Review of review.
See, the situation is not something which is usual. So, but then the point is, the judgments have to be technically correct on legal fronts. Right?
No, I appreciate it, Lord. We are in a very
thinking aloud.
slightly tricky.
We are just thinking aloud. You cannot brush aside.
Yes.
This business of brushing aside observations here and there, particularly when an act, a statute is under challenge, that may not be a safe course of action. Whatever we do or we don't do,
to
it
set
has to be
aside to set aside a statute, the grounds are very limited.
very,
We'll
very
have to
limited.
satisfy lordship that with these are the grounds, we come within this. four corners.
So, as we said, so far we found that there is some substance in the argument of 311 proviso, which of course they are yet to address the court. Because it appears that there is a dimming fiction under 4.1, which in a way confers some semblance of right. To
Not
what
some
degree
semblance.
we'll have to see.
I would say it's a right, acquired right.
This right ordinarily would have protection of section 6 of the General Clauses Act. But then the court order says it is not necessary. And by taking a leaf out of that, the new law itself says, forget the people who have not got it. Even the people who have been provincialized, their case also will review.
That will in accordance with this law.
Where is the provision in this law to review?
No, that they have not done.
Assuming that they do it, that means your client, these people have been deprovincialized.
So, my lord, question is, in a savings and reapings provision, there cannot be any question of contingency. I think somewhere something has gone wrong, subject to correction. Normally, you repeal a law, despite repealing, you save some right.
Please look into
That's the role of a repealing and savings clause.
Please look into this aspect. We
Yes.
want a little.
It's
clarity.
beyond the scope of a savings and repealing clause to bring in some more contingencies. And with great respect, that's
This-
my view.
This is what has
That's
happened
my
here.
submission, my lord.
This is what has happened apparently.
Yes, apparently.
So of course, the state has yet
Yes, they have not.
to address the code.
Anyway, we have, we've got a fair amount of, views which you'd like to address, your lordship.
We want to see, maybe some provisions may have to be read down or whatever, we don't know. But at the end of the day.
No, my lord,
people-
I will be arguing one more series where that number is fixed, 3. That I'm addressing, I'll be addressing. Another is the tutor part. Because you don't have certain qualification, you won't be provincialized as a teacher, but you will be provincialized as a tutor, whereby we'll be entitled to only a fixed remuneration. While for imparting education, somebody will get 1 lakh rupees, the others will get 18,000 rupees. That's the third category.
But then there is an intelligible differential in that qualification.
No, intelligible differentia is there. The Supreme Court has said, if for certain higher qualification, you give them higher scale, no, I'm not saying I must be equated with them. But question is, can you keep me as a tutor for entire lifetime to come?
That is the problem.
Yes.
Because that is where can the courts go into and question the wisdom of the decision?
It's not a question of wisdom.
Then-
Question is whether the classification is proper. If it is proper, Lordship will uphold it. If Lordship finds that classification is improper, then Lordship will strike it down.
But the problem is propriety is not the issue. Violation of Article 14.
I will satisfy. That will be our case.
If that is satisfied,
Yes.
then yes.
How can a person who is both mandated to teach, somebody will be a teacher getting a regular scale, somebody because a particular
I understand.
qualification is not there.
Maybe because of with the advent of the new act, it is possible that it'll rub some of the teachers in a very rough way. That is a possibility. And this could create a very harsh situation. That also we appreciate. But to strike down that act, none of these are the considerations.
You have teachers. If somebody is not, don't give them. Why are you giving this pretense? Well, end of the day, we are a welfare state. You have a duty under Article 39, you have a duty under Article 43. You can't, just ignore those.
So you are basically complaining about the amount of pay.
Not only amount, the description of our job and the status of our, the status to which has been given to us. Merely because I do not have a particular qualification, you don't give me. The fact that you have decided to give us lower scale. How can you give us fixed pay? Can we conceive of a fixed pay concept in a state regime, my lord?
So are you arguing?
Yes.
That either give me a fixed pay or throw me out?
Yes, of course. You can't do all these things. All right, somebody is having higher qualification. That's why the classification would be, you would be entitled to higher scale. I do not have particular educational qualification. I may be entitled to a lesser scale, but not a fixed pay like 18,000 rupees. Yes, Lordship is absolutely correct. On the basis of higher qualification, there can be a classification. So I'm not complaining of that. I'm complaining of the treatment which has been meted out. Can this withstand scrutiny of Article
But
14?
this threshold qualification is also prescribed by other central statutes. The 2009
In
Act.
some cases, what has happened,
Hmm.
that NCT regulation came in 23/8/2010, and these teachers were appointed much before that. Even they have applied there also.
Correct. But they were not employed as government.
No, they were employed as a ventures
Correct.
institution.
So now when it is a stage, no, we are putting this question so that you
the
can.
NCT regulation says those teachers who were appointed prior to this date, they did not have this qualification. There is a batch of case of that also, where I am appearing.
Okay, then.
There also, my lord, they have been made a tutor.
All right. Then we will.
Yes.
All right, then.
My lord, in that Somesh Thapial's case, Supreme Court has dealt with this aspect regarding the, my lord, with a higher bargaining power of the state, when people are compelled to accept appointments of this nature.
That's right, but Mr. Chaudhary, the problem is we are here hearing a matter
I'll, no,
challenging the
no,
legislation.
I'll satisfy your
Other
lordship
facets-
purely on the unconstitutionality of the legislation, nothing beyond that.
Constitutional virus,
Yes,
that's all.
yes. Only 3 grounds available.
And if there is.
And now because of the recent judgments of the Supreme Court, starting from Naptez and all, another ground has come to be added, that is manifest arbitrariness. And 3 grounds are already there, 1 more ground is now added, manifest arbitrariness.
Navtoj Singh, Justice D.Y. Chandrachud for CJI.
Naptez, then the Sriya Senghal, and all these cases. Where this concept of manifest arbitrariness, in a case, recent case of Manish Kumar with Cell Place, where law has been clearly laid down, tracing the law, dating back to old cases. And I'll not take long, I'll be precise.
Arbitrariness in.
Yes, manifest arbitrariness is a ground for, interfering with a legislation.
Manifest arbitrary.
Manifest arbitrary. Not only in 1 case, 4 cases. That means I filed to the other. Judgment of filed. Yes. In 2021, 5 SCC page 1. Paragraph 60. This view, namely, that be it a plenary law, if it is found to be manifestly arbitrary, it becomes vulnerable, has been followed in the following decisions. Naptez, Joseph Saini, K.S. Puthuswamy, Hindustan Construction. 4 cases. Manifest arbitrariness is another ground which has now been judicially evolved as a ground for interfering with even plenary legislations.
This is a plenary legislation.
As long as it is made by the legislature, it is a plenary. Or sometimes we call primary legislations. And the others are, my lord, either subordinate or delegate. When pursuant to provisions in the Act, legislation is made, it is delegated. And those where, my lord,
The statutory rules, etc.
and in some cases where executive makes certain legislation,
Delegated.
then it is subordinate legislation.
All right, then, what are the points?
Yes, I'll address.
Please give us some assistance. Yes, Mr. Datta, you can
Madam.
go ahead and conclude.
Madam, but I'll place one more judgment, madam.
Acha, Mr. Majumdar, the learned advocate general will appear.
Yes, he'll appear.
Please tell him that Monday after 1 hour, we'll proceed with the state's argument. The most 1 hour by Mr. B.C. Das and Mr. K. Chaudhary. And as we have already mentioned, because it is a special bench, in between, the question of adjournment will not arise. So we have to complete it. We have to complete it. Yes, what is this?
This is on, my lord, with regard to, my lord, how the repeal, my lord, the act, my lord, is to be, my lord, looked into, my lord. This is, my lord,
What is the point, Mr. Datta?
my lord, here, my lord, I would like to, my lord, with regard to, my lord, section 6 of the General Clauses Act, my lord. Para 35 onwards, my lord, I'd like to rely upon. This citation, my lord, is
Para 30?
35 onwards, my lord. In this view of the matter, section 6 of the General Clauses Act would be inapplicable. It is therefore not necessary for us to examine it, if any right to enforce the award on the old act accrued to a party where the arbitral proceedings has commenced before the coming into force of the act, and so has acquired a right to challenge the award made under the act. And there would be corresponding right with the Thesan to enforce the award, so and so. Present day, the courts tend to adopt a purposive approach while interpreting the statute, which repeals old laws, and for that purpose, to take into account the objects and reasons which led to the enacting of the new act. We've seen this approach adopted by this court in so and so. Provisions of
You are
both,
reading from para?
para 35, my lord.
Just 1 minute.
Starts with in these views, my lord.
Yes.
My lord. Para 36, my lord.
Hmm.
Present day, the courts tend to adopt a purposive approach while interpreting the statute, which repeals the old laws, and for that purpose to take into account the objects and reasons which led to the enacting of the new act. We have seen this approach adopted by this court in so and so. Both the provisions of this act, old and new, are very different, and it has to be it has been observed in so and so. In this case, this court has also said the provisions of the new act has to be interpreted and construed independently. And in that, in fact, reference to old act may actually lead to misconstruction of the provisions of the new act. The court said that it is would be more relevant while construing the provisions of the new act to refer to the so-and-so model of law rather than the old act. In so-and-so, my lord, this is not relevant, my lord. Then, my lord, paragraph 37, my lord. In Paper versus Hurt, so-and-so, House of Lords for the first time accepted the principle the judges could refer to the parliamentary debates in order to ascertain the meaning of an act by Parliament. Lord Griffith said that these days they have long passed when the courts adopted a strict constructionist view of the interpretation which required them to adopt a literal meaning of the language. The courts now adopt a purposive approach which seeks to give effect to the purpose of the legislation and are prepared to look at much extraneous materials that bears upon the background against which the legislation was enacted. But if the construction of the new act leads to inconvenient, unjust results, the concept of purposive approach has to be shed. My lord, then, my lord, of course, the next, my lord, the remaining parts will not be that relevant, my lord. Then, my lord, I'd like to, my lord, place section 38, my lord. Sorry, my lord, paragraph 38. Section 85(2) is a saving clause. It exempts old act from complete obliteration so far as pending arbitration proceedings are concerned. That will include the whole or saving of the whole of the old act until the time of reinforcement of the award. This section 85(2)(a) prevents the accrued right under the old act from being affected. Saving provision preserves the existing right accrued under the old act. There is a presumption that legislators intend to limit or take away vested rights unless the language clearly points out to the contract. It is not correct to say the new act is a remedial statute, and therefore 85(2)(a) calls for strict constructions, it being a repealing provision. But then, as stated above, where one interpretation would produce an unjust or an inconvenient result, and another would not have those effects, then there is then also a presumption in favor of the latter. Then, my lord, paragraph 40. Various decisions have been cited before asked to show that where the mere right, what is a mere right, and what is right accrued or acquired. We have to examine this question with reference to provision of section 6 of the General Clauses Act. If it could be said that when the arbitral proceedings have commenced under the very old act, a party has acquired a right to have the award given thereafter, enforced under the old act, the question that arises for consideration is that if the right has accrued to the party is a mere right, to the party, or it is merely an inchoate right. These cases referred above so-and-so, so-and-so, and so-and-so show that something more is required than the vested right to accrue. Right did exist, but then there is nothing was done to show that the act was done or advantage was taken of the enactment under which the right existed till it was repealed. An act gave the right, and the new act which repealed the old act took care of the right. Mere taking of a right, taking advantage of a mere right to take advantage of the provisions of an act is not a right accrued. Then, my lord, therefore, my submission will be here, my lord, that here it is not a right, my lord, which was, my lord, to be for right for consideration. It was already right accrued, my lord, so far that those who have completed 7 years are concerned, my lord. With regard to those who have not completed 7 years, my lord, it was a question, my lord, that as and when, my lord, that right did not, my lord, crystallize. So the legislature, my lord, distinctively made this distinction, my lord, on their wisdom that, my lord, they created two classes, my lord. Those who have completed 7 years, my lord, they were deemed to be provincialized, my lord. So that is a right, my lord, which is crystallized. And therefore, my lord, these people, my lord, who have been provincialized under the earlier act, my lord, they were, my lord, these are the present batch of petitioners, they are treated at par, my lord. They cannot be differentiated, my lord. And, my lord, therefore, my lord, in my humble submission, my lord, that the present, my lord, provisions which have been now brought in, my lord, apart from, my lord, being violated 14 and 16, my lord, they're also manifestly arbitrary, my lord. What is manifest arbitrary, my lord, has also been, my lord, discussed in various decisions, my lord.
All right.
Something, my lord.
Anything else?
Well, otherwise I would adopt the arguments which have been laid down, made, my lord.
Mr. Via was there in some, then after that.
Well, I have also prepared written synopsis.
Lord, I am very sorry, my lord. I was late, my lord.
Call someone.
My lord, in one matter, my lord, I have a instruction to withdraw not to press, my lord, with a liberty, my lord.
Which matter?
My lord, item number 81, my lord, Dr. Lukman Ali, my lord.
You want to withdraw?
My lord, withdraw with a liberty, my lord. Just for near future if it is required. my lord. Some litigations are pending before the single judge also, my lord, with we are going on, my lord. Not civil,
Liberty to?
liberty to file a fresh.
As and when a fresh cause of action. arises.
My lord, my lord.
That liberty is not required.
Sometime it
Apart from that,
My lord, in other item number, my lord, 82 and 83, my lord, here we are challenging. If my lord may be pleased to take up item 83, both are similar, my lord. Item 82, my lord.
yes. That is ZA.
My lord, that is the provision of the Dias code, my lord. And we are, my lord, in item 82 are the regularly appointed science teachers, my lord. Petition to them. And only because of the bar, my lord.
What is the issue with Dias code?
My lord, the Dias code, what they have done, my lord, in the definition of the Dias code, they have said that every school which are, my lord, seeking provincialization under this act is required to have a Dias code, district institute of system for education, my lord, maintained by, my lord, may find the definition part, my lord. The Dias code definition, my lord, is at page 103 of this manual, my lord.
You called him?
Books.
You called him? 103.
Page number 103, my lord. This is a part of definition 2I, my lord.
Yes.
May I read, my lord? Dias code means the district information system for education code prepared by the Sarva Shiksha Abhiyan Assam and is available in the records of the National University of Educational Planning and Administration, New Delhi. So, my lord, it has been prepared by the Sarva Shiksha Abhiyan Mission and it has been sent, my lord, for recording by the National University of Educational Planning and Administration in New Delhi. Now, my lord, the problem arises in our case, my lord. My lord, may kindly turn to page 106, my lord. Answer ME school, no? Z. My lord, I am referring to the definition of Bhansar ME school, that is at definition ZA, my lord. Including the Bhansar ME Madrasa means an upper primary school, imparting education from class 6 to class 8 and established by the people of the locality prior to 1/1/2006, which has received the recognition from the competent authority on or before 1/1/2006 and captured in the Dias code up to 2009 and 10. And whereof the services of the teacher have not been provincialized under any act enacted by the state legislature so far. There is not proviso has been given, provided that the Dias code shall have to be issued on or before 2009-10 and Dias code issued thereafter shall not be considered for the purpose of provincialization of services of any employee of the institution. Now, my lord, if the department has rejected our provincialization, my lord, what has happened? Our name, my lord, in the 2009 and 2010 Dias data, which they have maintained, has not reflected, my lord. That is the reason, precisely, my lord, they have treated that this Dias code should also include the entire description of the school as well as the teaching and non-teaching staff of the school, my lord, who were working at that relevant period of time. But, my lord, if we go by the other definition, my lord, this has a contradiction, my lord. Because if my lord may be pleased to peruse section
So,
two,
so your case is
my
that
lord,
although your client should have got the DIAS data before 2009,
my lord,
due to some malfunctioning at the administration,
My
level,
lord.
that did not happen.
that did not
And
happen.
then this act came with the provision,
Yes, my lord.
which has in a way.
In a way, my
Divide.
lord, with a retrospective effect, 2009-10 has been provided, my lord.
Hmm.
So in 2009-10, admittedly, my lord, our name is not there, my lord, as a science teacher, although we are the only science teachers in our respective school. As per section 3.1.11, my lord, there is a provision for one science teacher. My lordship has already gone through section 3.1.11, my lord, that one science teacher should be there. Now, my lord, excluding us, two of the teachers has already been provincialized. Now, my lord, why we are challenging this section? This has a contradiction with the, if we go by the definition of section 2J, my lord.
No, Mr. Bhuya, what
My
I'm
lord.
trying to ask you is,
My lord.
it is one thing to say that the provision itself is bad.
My lord,
That's a onerous task.
my lord.
You may or may not succeed, that we
Yes,
don't
my
know.
lord.
It is another thing to say that in my case, the department has treated me in a manner which is violative of my rights.
My lord,
If your actual problem is the second one,
my lord.
and you come in this group, then if the provision is not interfered with,
My lord.
it's over for your client.
Then it will be difficult for
So
me.
therefore, we are asking that if your individual grievance is the action of the authorities,
My lord.
then why are you taking in this procedure
my lord.
where only the virus will be challenged?
My lord, because the authorities are saying that, my lord, 2009 and 10, if an incumbent name is not included as per the provision of this, my lord, ME school definition, then there is no scope of provincialization.
So your case is that your name should have been included.
Should have been included.
Then why are you challenging this?
No, my lord, as they have said that as our name is already not there, they have not included.
Depends on what you have understood.
I have understand, my lord. I have understand.
If on that ground you don't, then it's over, end of the road for you.
My
That
lord,
is the risk you are taking. We told it to somebody else
My
a
lord.
while back. Unnecessary, you are, in
Then, my
these
lord.
cases, we are not going to refer to any individual facts.
My lord, that
Only
is
the questions whether any of
constitutional validity. I can
Nothing
understand,
else.
my lord.
So if it is held that Z2A is valid,
Valid, my
it's
lord.
over for you.
And it will be,
Oh, and you will be remediless. And we'll mention it in the judgment.
my lord, it can also be heard by single bench
That we
also.
don't know.
My
But
lord.
if you want, you take it away, segregate it. But
My lord.
otherwise, अच्छा ये तो लिखो क्यों?
Uh-huh.
Item.
And prayer.
Item 81 लिखो.
No, 81,
81.
Lokman Ali Udro.
WPC number 310/2022. Mr. A.R. Bhuya, Lord Counsel for the petitioner, submits that he has instructions from his client not to press this writ petition. Post up. However, the petitioner seeks leave and liberty, seeks liberty to approach this court by filing a fresh writ petition as and when new cause of action
Mal.
arises. The prayer made by the petitioner's counsel is not opposed by the learned departmental counsel, Mr. R. Majumdar and Mr. K. Gogoi, who are present before the court. In view of the above, this writ petition stands disposed of and withdrawn with liberty as paid for. All right. So in item 82,
My lord.
it was item 81. All right, you complete your argument. What do you want to do?
My lord can segregate this, my lord, and
On the request, Mr.
Fine.
A.R. Bhuya, learned counsel for the petitioner 82, submits that in this case, the petitioners are aggrieved due to the fact that despite being eligible, their names were not included in the DIAS code
Dias code.
prior to the cutoff date
My lord.
introduced by section 2 bracket of ZA bracket close of the Act of 2017,
17, my lord.
Act of 2000 Assam Education Executive Provincialization of Services for Teachers and Reorganization of Educational Institution bracket Act bracket close Act 2017, and therefore their services could not be provincialized.
My lord.
After hearing preliminary arguments of the petitioners' counsel, this court is of the opinion that the petitioners are primarily aggrieved due to the arbitrary inaction on the part of the respondents in their failure to include the names of the petitioners in the Dias code, and not so much by insertion of clause 2 bracket Z. In view of the above, and on the request of Mr. Bhuya, this writ petition is directed to be segregated from this bunch of writ petitions and listed separately as per roster after the summer vacation.
The next one is also same, my lord. 83 is also same, my lord.
District Scrutiny Committee.
It's same.
My
It's the same order.
My lord.
These matters, these writ petitions. 82 and 83. 82 and 83. So 84 we have already had.
25.
Obliged, my lord.
Who's there? Group 25?
These are similar to item 78 to 80, Lordship. These are also PGT teachers. Means they have, they were earlier appointed as PGT teachers. Subsequently,
These
they
are
were-
similar to?
Lordship, 78 to 80.
78. 21.
Group 19.
21. 21.
Group 70.
Group 21. Additionally, Lordship, section 6 has been, 6.1 and 6.2 has been challenged here in Lordship. Lordship, that has also been argued by my senior Mr. A.C. Borba, Lordship. It is with regard to the educational qualification of those. I adopt those arguments. Lordship, herein, I want to add one more thing, Lordship. There is a schedule appended.
Yes.
Lordship will have this book at page 127. There is a schedule appended, Lordship. Herein, the pay fixation of pay has been given, Lordship. Lordship, this fixation has been made on what basis? That has not been said anywhere, Lordship. But Lordship, it has been seen that the minimum pay prescribed by the 7th Pay Commission was also denied in certain cases, Lord.
All right. Anything else?
No, Lord.
Group 25 over.
Right.
Then
Group 26, item 97.
Because this can be segregated, your lordship. This is your lordship relating to, we have put the section 8 to the challenge, but it relates to your lordship, new pension scheme, your lordship. Therefore, your lordship, the contour of argument, your lordship.
item 97. लिखो. Mr. S. Bhattakur, learned counsel for the petitioner, submits that although section 8 bracket 2 bracket close and bracket 5 bracket close of the Act of 2007 have been challenged in this writ petition, yet the grounds of challenge is pertaining to introduction of new pension scheme, and therefore the issue involved in this writ petition is different from those in the bunch of writ petitions. On such count, Mr. Bhattakur prays for segregating this matter from the bunch of writ petitions listed today, and with a request to take this matter separately. Since the prayer is not opposed, same stands allowed. Office to segregate this writ petition from the bunch and list it separately as per roster. Yes, group 27.
Deeply obliged.
So there is one matter left. So in these cases, you write, disposal or segregate, list again for further hearing on Monday.
My lord, I just have received information The learned AG perhaps would not be here on Monday. We are very good.
We'll close it. Can't help it.
And if Lordship,
Submit written arguments.
and if Lordship permits me that group wise that classification that Lordship will have a look and just tell me whether something like this will suffice or
Yes, yes.
the first group, my lord, we have made is the school was established before 1106, but either recognition. or
Yes, yes,
permission.
exactly. This is what we want.
Then school was although existed, permitted or recognized, but not captured in the dais that was argued at the end. And teachers and tutors teaching special subjects could not be provincialized due to less number of students. Although their incumbents in other subjects have been provincialized in the same school. Then there's a venture primary school, only one language teacher has been provincialized, although there are compulsory other languages required in the school. The ME Madrasa, Arabic is what my senior BC Dastar is agreeing. And although all teachers in the venture institutes are discharging similar duties, one set would be a tutor who would not have the same status and salary, is what one of the grievance there is. And the last is that the fate of the provincialization is made subject to the performance of the students or the appearance of the students. Those are the basic things we could find out, my lord.
And section 24 will come.
Section 24 will come at the end of the day. Hmm? No, don't call it return arguments. It is separate matter.
Monday.
Separate matter.
Monday we'll have it.
Monday.
Time being matter, I can say. I don't mind.
Heard Mr. K. Raman Nayak, counsel for the petitioner, also heard Mr. RKD Chaudhary, learned DSGY, appearing for the response number 1. Mr. A. Ali, learned standing counsel ECI for response number 2. Ms. A. Verma, learned standing counsel Home Department, Government of Assam, for the response numbers 3 and 6. And Mr. P. Sharma, learned Government Advocate Assam, appearing for the response number 5. This writ petition has been preferred against the judgment and order dated What is the date of the judgment?
28/5, my lord. 28/5/2024.
You have not mentioned it in the synopsis, right?
27/3/2024.
27/3/2024.
Page 113.
Rendered by the learned member, Foreigners Tribunal, bracket 4, bracket close, Darang, in connection with Mangaldoy FT 4th, case number 1322/DHL/2015. Declaring the petitioner to be a foreigner of post 1971 stream. Mr. Rahman submits that this is a contested matter. The learned full stop. According to the petitioner's counsel, the learned foreigners tribunal has failed to appreciate the evidence in the correct perspective. Hence, the matter calls for examination by this court. Full stop. After going through the impugned order, we are of the view that the writ petition deserves to be. We are of the view that the matter calls for deeper examination. Issue notice returnable in 6 weeks. Since the response numbers 1, 2, 3, 5, and 6 are already represented, no formal notice is required to be sent to said respondents. Extra copies of the writ petition will be furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon response number 4 by registered post with AD within 7 days from today. The name of the response number 7 is hereby struck off from the record. Why have you made the member a party? The petitioner to file amended cost title within 2 weeks from today. Call for the LCR. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that till the returnable date, the petitioner shall not be deported or arrested by the police subject to his appearance before the superintendent of police bracket border Darang and furnishing a bond of rupees 5,000. And also recording the biometrics and as well as iris of the eyeballs of the petitioner in accordance with law.
Yes.
These matters will come again on Monday.